do things. This is a review, see what progress you're making on those things you're ordered to do. So when your name is called for review, come up to the table to your right, stand there. I'm going to go over your file with you. And generally, people that owe community service or fines, we have the 7th of October is Union Township Cleanup Day, and I'm going to give double credit for that day. It's a Saturday, so if you owe community service and you come out and work, you get 2 days credit for doing one day, or if you owe on your fine, you get $100 credit off your fine instead of $50. You usually give $50 off your fines and costs if you work an extra day of community service. So, call the reviews, please.
Brandon Ainsworth, Alicia Clay, Matthew Fortner, Brandon Gannon, Edward Gearhart, Tia Hammond, Elizabeth Hoffman Howard, and Stephen Murphy.
Brandon Ainsworth.
Yes, sir.
20-2250, case number. Okay, you still owe 3 days community service?
Yes, sir. I called Thursday and asked, because my car's in the shop right now getting the front end fixed, and asked if I could do it in Ironton, and they said that, I guess that was not an option, that Common Pleas would give me credit, but you guys wouldn't, so I'm having trouble getting up here until my car gets out of the shop.
Okay. You live in Ironton?
Yes.
I think what the problem is, Your Honor, is that if he goes to something in Ironton, it's going to go to Common Pleas Court first before it comes to us.
Okay.
And I am working on Common Pleas also.
Yeah, well, that's fine, but you don't get double credit. You're not going to get credit.
That's fine.
For both Common Pleas and this court.
Well, yeah, correct.
For community service. So you still have 3 days left to do. If you come here on Saturday, October 7th, you'll knock 2 of the 3 days out.
Yes, sir.
Do you have a payment on your fines?
Yes. How much do I owe?
I'm showing $215.
Okay, I can go pay $100 today.
Okay, see the clerk to make your payment.
Okay.
I'll set your next hearing for November the 6th. If you get everything finished by then, you don't have to come back.
Yes, sir.
November 6th at 9 o'clock.
Thank you.
Alicia Clay is 2268. Alicia, was that Southern Hope, or are you still at Southern Hope?
Yes, I wasn't aware she had court today. She's got a different last name, I guess, than what she goes by at our place. But she is compliant and is passing all her drug screens as well.
Okay.
And I just got a job, that's why I haven't been able to do the community service, but I'm
Where
going to
are
try.
you working at?
The Winchester in Ashland.
Okay,
And I'm going to try to request off for Saturday so I can get that double time.
okay.
But I am making $50 payment today.
Okay, very good. Good job then on your treatment, and you've got 15 hours of community service left is what it shows.
Okay.
So see the clerk to make your payment, and I'll set you for November 6th also. 9 o'clock.
Thank you.
Keep up the good work with your counselor.
Thank you.
Matthew Fortner. Matthew Fortner has been called, hasn't appeared, 16-2079, 16-2056. There'll be a warrant for failure to appear. He was supposed to be at OVP. Is Brianna here?
She was, Your Honor.
Okay. Well, if she can find out if Matthew Fortner has been to OVP. Oh, okay. Yeah, I can introduce him. Brianna, do you know if Matthew Fortner, he had told me in his last hearing he was going to be going to OVP for some counseling. Do you know? Can you find out?
Not that I know of, but I can find out. I can call and check.
And he didn't show up for his hearing today, so
Yeah, I will get a report.
thank you. Brandon Gannon. Brandon Gannon was called for, didn't appear, 22-2402. It's OBI. So there'll be a warrant issued for failure to appear. Okay, if you ladies want to come on up, I'm going to let you go ahead. I forgot that you were going to be here today. So So we've got some guests here from Nationwide Children's Hospital, and I'm going to let them introduce themselves and tell us about the project that they're working on and who's eligible to participate in it, and you can actually get paid to participate in this project. So if you would introduce yourself and tell folks about what's going on.
Hi, good morning. My name is Zara and this is Kat. You might recognize me as I was here 2 weeks ago with another colleague. We're here from Nationwide Children's Hospital working on an overdose prevention court study. The purpose of our study is to look at different intervention strategies for reducing the risk of overdose among people who have used illicit stimulants in the last year. So if you are attending court today and you think you might be in that category, you're more than welcome to just meet with us. I'll emphasize that our study is voluntary. You can choose to enroll and you can always unenroll at any time. It is confidential. None of the information you share with us can be shared with anyone else in the court, and it is paid. So if you choose to enroll today, you receive $25 right as you enroll, and then each survey you complete with us over the span of 2 years, you'll get bi-weekly surveys. Each bi-weekly survey is $5. At 6 months, you'll receive a slightly longer survey, and that's $35. And today's the only time you really need to meet with us. After that, it's fully remote. So if that's something you might be interested in, just answering some survey questions with us, you're more than welcome to just come and meet with us. I think we'll be in that back, that back room.
We call it the attorney room. It's where the attorneys sometimes meet with their clients, and it's on the west side of the building. So if you don't know where it is, you can ask the security or any of the other court staff, and they can direct you how to get back there to meet with them. And they're not going to share the information with me. I won't know what you tell them. The whole idea, I think, is to collect this data, analyze it, and see what is most effective to help people avoid overdoses. So you'll be helping the community by sharing this information. May help somebody down the line in the future that's gone through what you've gone through, help them avoid an overdose by sharing the information from your history, from what you've experienced.
Exactly. We really value, even if you just want to come chat with us, you're not sure you want to enroll, that's totally fine. It only takes about 15 to 20 minutes total for the enrollment process, and then again, the rest of it is remote. So we'll be there, and feel free to stop by after court. Thank you.
So to be able to do the remote, you need either a smartphone or access to a computer.
Yes.
Right? And that's the only qualification, other than having the experience.
Correct.
Okay.
Thank you.
Thank you for introducing. Because we get quite a bit of turnover, I'll try to keep reminding folks that you're here today. So thank you.
Thank you so much.
Thank you.
You're welcome. Okay, let's go back to our reviews. Hobart Earhart is not here.
Your Honor, we have an update.
Mr. Gerhardt is in Gay County Jail. He's being transported back to Lawrence County. I'm going to place him in inpatient today.
Okay.
He's got common police court charges, Your Honor, and I think he's going to monitor.
Yes.
All right. So I'll go ahead and do another review for him in a month. Let's make it November 3rd.
Thank you.
So hopefully he'll be at your facility then,
Yes, sir.
inpatient, you can bring him to court. So you'll make sure he gets to court on November 3rd.
Yes, sir.
November 3rd, 9 o'clock.
Thank you, Your Honor.
Tia Hammond. Tia Hammond. She was at RRG. Did I order her ankle monitor removed already, or was I making a note that it would be removed today? If you have access to it, or I don't see an order for it. Heather from RRG not here today, is she?
I don't see her, Your Honor.
No, she isn't.
Okay, I see you sent me a text about Matthew Fortner.
No, that was Matthew White, the one
Oh,
that's
okay.
currently in the jail, but Matthew Fortner hasn't attended any appointments at OVP since April.
Okay.
I have a Matthew Fortner too. Through Connor, please. I wonder if it's the same one.
It probably is.
See inpatient?
He's outpatient, but he's a fast graduate.
Okay, he failed to appear for a review hearing today.
Well, great. Okay, I'll send you a message right now.
Okay. All right, Matthew White.
Yeah, they just informed me of that this morning, or I would have let you know sooner.
So she's at your facility, and you don't want to bring him to the same facility. So can you talk to some of your colleagues and see if we can find a bed for Matthew White?
Yeah, I'll work on it. Thank
Okay,
you.
we'll put it on the docket for later. Okay, Tia Hammond did not appear. I had a note about an ankle monitor, but I don't know if she actually had an ankle monitor on or not. And I was going to text Heather at RRG to see if she can give me some information. It's Heather Fields, I think, is that right?
So you wanted to know what I've heard about you from your son?
Okay, so I'll mark it for a warrant since she didn't appear, but I'll ask for a report from RRG. Elizabeth Hoffman Howard is here today. 220164 and 193458. Okay, you got a good report today. Congratulations, you look great.
Thank you.
And can you make a payment today on your phones?
I can this Friday.
Okay, you still have some community service.
Yes, I do.
And you know about the double credit on October 7th?
October 7th? Yes.
You still have 24 hours to do, you need to get that knocked out.
Okay.
I'm going to set you for October 30th as your next hearing.
October 30th.
Okay.
Thank
you're
you,
doing
Jessica.
well, keep it up.
Thank you.
Stephen Murphy. Yes, sir. 220070.
Your Honor, he has discharged from community service.
Okay.
He done it at the Lawrence County Court. And the judge.
Okay. You have a payment on your funds today?
No, Your Honor. I just planning on doing community service too.
All right. Then you are a veteran, right?
Yes, Your Honor.
Are you availing yourself of any of their services?
I'm trying to get in. They told me it was special circumstances that I could get treatment. I'm trying to talk to a lawyer to see
You can do
what.
outpatient, I think. I mean, if you're talking about inpatient.
I can't even get an ID card at this moment.
Oh, okay. Have you talked, do you have a contact person at the VA?
No, Your Honor.
Let me give you the phone number of somebody to contact there at the VA to see if they can help you. I know this person is pretty responsive. Her name is Amanda Rayburn. And she can help people. So are they saying you're not eligible for benefits, or questioning whether you're eligible?
It's an honorable discharge. I'm really not sure what the problem is.
Okay. Let me give you her contact information. Because has been very helpful to me with folks that we have from this court to get them help. 304-590-1111, or I'm sorry, 1167, 1167. Amanda Rayburn.
Thank you, Your Honor.
And I'll set your next hearing for November 6th.
Thank you.
You're welcome.
Whitney Piles, Kaylin Rose, Betty Ross, Robert Struble, Jessica Thomas, Robin Varney, Harold Weaver, and Don Williford.
Whitney Piles, 19343. Looking for work now, or is that the next step?
Yes, sir.
Okay, it's a positive report, so very good. So we'll wait, you probably can't pay anything on your fine since you don't have a job yet, right?
No, sir. I'd like to just do the community service.
Okay, you can do that, extra towards your fine and costs, actually, so. I'll set you for November the 10th. November 10th will be your next hearing.
Thank you.
9 o'clock. Once you get everything finished, you can quit coming to these hearings. Kaylin Rhodes. You're Kaylin? 21,834. Okay, you did do some community service. You still have some, I'm saying 3 days left to do.
I'm not exactly sure how many hours it is, but I think 2 or 3 days would cover it.
Your Honor, she was here Saturday. I don't know if that
Okay, well, that wouldn't be in here yet. You're doing Saturday, so you probably just have 2 days left. You need to get that knocked out in the next time frame. Do you have a payment on your costs or your fines and costs?
I was running late, so I didn't stop at the ATM, but I'm gonna leave here and go to the ATM and come right back, so,
Okay, and you also have to do the driver intervention program. Have you done that? I don't see that.
no.
Okay, get the information from Mr. Major. The closest one is in Portsmouth now. There is not one here in Lawrence County any longer.
My dad had to do something like this in Gallia, and I was talking to him about it, and he said that, it's strictly over line, like online now, and I told him that I didn't think that was,
That's not correct.
yeah,
No, it has to be inpatient where you go stay for 3 days.
yeah.
Okay, I'll set you for November 3rd, 9 a.m. Betty Ross, 16,530, Betty Ross. Hasn't finished and didn't appear, so she gets it one. Well, actually, let me check. I think she may have a bond up. She does have a bond, so it was just posted in July. So it should have been on the sentencing docket, but I'm sure she was told to be here at 9. I'll set it aside just in case and call it at the end of the docket. If she hasn't appeared, then bail bondsman will have to go pick her up. Don Williford is here.
Yes, sir.
21,3491. And, yeah, got a report, Mr. Cooper?
No. Oh, sorry. I'll message you.
Yeah, you might have him, see if you can get Betty Ross in. Okay, Lawrence County Recovery. Good report. You don't have a whole lot left to do on your case.
I'm paying $100 today.
Okay. All right, I'm with your report and you paying that, that's gonna finish you up, so your case is gonna be completed. So see the clerk and make your payment and you're done.
All right, thank you.
Good luck. Robert Struble, Robert Struble. 22-2761. He hasn't done anything on this case, so he gets a bench warrant. Jessica Thomas, 2372. Sat Mahajan. We got a report from Mahajan. It's a good report. And if you finish this up and finish your treatment at Mahajan, you won't have to go to the 3-day school. That was part of the sentence, so.
Yes, sir.
And you did make a payment recently on your fines. I see that.
Yes. I have a payment today as well, and I also turned in my community service this morning when I got here.
That is correct.
Okay, very good. Good job. I'll set your next hearing for November the 17th. If you get everything done before then, you don't have to come back.
Okay. Thank you.
You're welcome. Robin Varney, called for, hasn't appeared. There will be a warrant for failure to appear. And Harold Weaver, 2398. He was supposed to go to ARC, and didn't show up. Be a warrant for failure to appear. Okay.
I don't have any arrangements for here.
Okay, just at the jail.
Just at the jail, they've been notified that they're not up yet, so.
There's one more now.
We can start some retrials.
Okay. We are going to have arrangements here.
I haven't been made aware of any.
Okay. We're going to start some pre-trials. If there are new cases, we don't have the paperwork on it yet, so we'll have the lawyers come in and start some of the pre-trials.
State of Ohio versus Richard Gray Jr., case number CRB 23557.
Okay, Richard Gray Jr. is Mr. Thompson's case.
He has a conflicting hearing down in Louisville, Kentucky.
Okay.
And it looks like the alleged victim wants to dismiss it anyway, so we'd ask for 1 week.
All right, I'll continue that at your request to October 2nd.
Thank you.
October 2nd for no trial.
Thank you.
10 o'clock.
State of Ohio versus Jason McCoy, case number CRB 23537.
That's a cross too, Your Honor, with an Aaron McCoy
Aaron McCoy.
and Jason McCoy.
Who's the attorney for Aaron?
I'm the attorney for Aaron. Jason does not have an attorney.
Okay. So it's Jason and Aaron.
Yes.
Yes, sir, but there's been a change in that. I apologize. The Lauders had some trial.
Your Honor, this is a domestic violence. It's a cross-filing. There is a protection order in place. I believe Aaron here would like to see a modification of that.
Yes.
They have a child that needs both parents.
Actually, I had, my note was that there was no TPO. Was there actually a protection order?
There was none on my behalf during the arraignment, sir, but I guess during the arraignment she'd asked for one.
Okay, there is one actually, so. So is she wanting that withdrawn or?
Yeah, we'll withdraw that, Your Honor.
So the protection order that's been issued against Aaron McCoy.
Against Jason.
Jason, I'm sorry, Jason McCoy is withdrawn.
And
so So at this point, Jason, you're unrepresented. correct?
I'm unrepresented. I'd like to have a court-appointed attorney if possible, sir.
Are you working?
No, sir, I'm not.
Yeah, no income?
I have no income. The lauder was more of a retainer issue here from the past, and he still is under retainer, but he told me that it would be weeks before he'd be able to even get with me, other than a talk from the phone.
All right, I'll appoint Mr. Thompson to represent you.
So, Your Honor, we had talked about them doing some counseling together, and maybe looking at that satisfying anything that the prosecutor might need on this case. You have a letter from Mrs. McCoy there.
Yeah, she's at RRS.
Yeah, she's in services. So, Your Honor, I just asked that maybe we could set this out, see how things are going, and then maybe come back and decide what we're going to do.
Mr. Hill.
Well, we're not opposed to that. I believe that our discussion previously was we wanted them both to take part in counseling. I don't know.
Yes, sir. The lady I spoke to outside about the appointment, she told me, of course, to get with the lauder, and when I spoke with the lauder, he told me that with it being set up as an appointment to go to her, that he would make the call to her, let her know that I was going out of town. I have a family friend who lost a family member. Me and my son traveled down there, and under the direction of Mom allowed the son to travel with me. We did a couple things for a couple days down there and came back, and that was during when that appointment was to be. So I don't know if the lauder followed up and made that call. If he didn't, then I do apologize.
Which agency?
I'm sorry, I don't see the lady.
Bethesda?
It's the one.
We'll get her to say.
I will most definitely go wherever I need to go.
Well, they probably need to go to the same, would you accept them both at the same facility?
Yes.
Okay.
Yeah.
All right. Come back in about a month then? Okay.
Yeah, it's fine, Your Honor.
Drop the coffee.
Your Honor, he was scheduled for September the 18th. We were waiting on his attorney to make a decision.
Yes.
And I haven't had a call or anything, so he'll need to be rescheduled.
Okay. Well, I think Mrs. McCoy's at RRS, so now the protection order is withdrawn. I think it makes more sense for them both to go to the same facility. So let's come back around the end of October.
Good dates. Just a second.
And Mr. Thompson, you want a Monday, right?
Please.
The 23rd or 30th, either one works.
Either one, Your Honor.
Either one?
Yeah.
23rd then, October 23rd.
That'll give me time to get ready, the kids ready for Halloween and stuff.
10 o'clock.
I'll do whatever the court asks us to do.
Okay, take your discussion outside, please.
State of Ohio versus Renee Bledsoe, case number CRB 23473, CRB 23475.
Okay, before we go any further, we've got new people circulating in. Let me just announce, we've got people here from Nationwide Children's Hospital that's doing a research project. And if you have used substances within the last year, they want to talk to you. It's all voluntary. I don't know anything about it, but you will get paid for participating. The whole idea behind this is to gather data about people that have used substances and try to collect it and to reduce the overdose death rates from studying the data, doing research, and you can participate. You'll get paid. I think it's 15 minutes per day. You get $25 for participating, and then every time you participate thereafter, you get paid via a card. What you have to participate is a smartphone or a computer, because after today, it's all online. There's no, and if you're suspicious that Big Brother is watching, you don't have to participate. It's totally voluntary. If you don't want to do it, don't do it. But they're in the back in the attorney room, they'll talk to you, sign you up, and you get paid for participating. And they're not going to, other than the gross data, I won't see individual. Like I won't say Joe Blow told him this, or John Smith said that. It'll just be, this is what we collect from the whole state of Ohio and try to cut down on the overdose death rate. Okay. Let's go ahead with this case. This is Ms. Bledsoe, Mr. Stratton's case.
Yeah, last time we were here on the 8th, the state was going to subpoena the alleged victim in this case and see where we go from there.
So, Your Honor, we did, and Mr. Robert McGuffin is here, and he has let me know that they've squared things up as far as the monetary damage to the tires, and he is not opposed to a dismissal because of that, and we are not opposed to it either.
Is that correct, Mr. McGuffin? Yes, sir. Okay. I assume you don't object to that?
No objection, Your Honor.
All right, cases will be dismissed at the victim's request.
Thank you, Your Honor.
You're welcome. Thank you. Okay, we've got an arraignment to do now, so we'll go ahead and do that.
State of Ohio versus Marissa A. Reimer, case number CRA 23540, A, B, and C. Marissa Reimer.
Ma'am, are you Marissa Weimer?
Yes, I am.
And it looks like you're at Southern Hope getting some counseling, so that's a good thing. You've got some charges filed, so we got to go over that. And before I do, let me tell you what your rights are. You have a right to remain silent. You don't have to say anything. If you do say things, it's all on the record, so if you admit something about your case, the prosecutor can use it against you. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, to make the state prove this charge beyond a reasonable doubt. You understand those rights? You're charged with possession of a fentanyl-related compound. That's 540A case number. It alleges July 31st of this year in Fayette Township, you knowingly obtained, possessed, or used a controlled substance that was fentanyl-related. That's a felony of the 3rd degree. Maximum penalty is 5 years in jail and a $10,000 fine. You're also charged in 540B case number that at the same time, July 31st, Fayette Township, you knowingly prepared for shipment, shipped, transported, or delivered a fentanyl-controlled substance more than 5 grams but less than 10 grams, and that you knew or had reason to know it was intended for sale or resale. So that's trafficking in drugs. It's a felony degree. Maximum penalty is the 5 years in jail, $10,000 fine. 540C alleges aggravated possession of drugs. That July 31st, you normally obtain, possess, or use methamphetamine, which is a Schedule II substance. That's a felony 5. The maximum penalty is 1 year in jail, $2,500 fine. So you've got 3 charges. Do you understand those 3 charges, ma'am?
Yes,
Do you have the money to hire a lawyer?
I do not.
Do you have a job?
Not yet.
All right, Mr. Scott, I'll appoint you to represent Ms. Reimer.
Thank you, Judge. This time they're pleading not guilty. Waive reading on the issue of bond, Judge. Ms. Reimer is here. She is self-instructing the Southern Hope Recovery Center. Seems to be doing pretty well. So we'd ask for signature bond.
Mr. Healy.
We're not opposed to that for the time being. We want her to stay in treatment as a condition of the bond.
We have no issue with that.
Okay. I'm just reading your report that was submitted from Southern Hope. Well, this is a felony, where there's a couple felony counts here, so I don't know. Is this one, the state knows it, will take to the grand jury, or is that a decision will be made? I lost Mr. Hill.
I assume just keep it here, Judge.
I wanted to hear it from him. Well, I guess I'm on my own then. I'm gonna let her sign a OR bond of $2,000. When do you want to come back for a preliminary hearing?
Judge, I'd want probably 20 days out, so I have enough time to get discovery from the state.
Okay. How about October 10th? That's a Tuesday.
That's a Tuesday, yeah. I'm open if you want to be here on Tuesday, Judge.
Yeah, well, the 9th is a holiday, Columbus Day.
Okay.
Your Honor, I was out of the room, but I did hear that there was some mention made of whether we would be willing to leave the case here or not. Knowing that there is a trafficking charge among those, there is a question about that. So we're going to have to look and see exactly what the facts are in order to make that determination. Also, if we're going to move the preliminary hearing out to October the 10th, we're going to need a time waiver. But it's also a good thing that she's going to be in treatment, and it can't hurt the situation at this point for her to agree to that.
So I assume that's agreeable.
Fine with me, Judge.
So they're saying there's a chance.
I'll explain all this to you outside.
That it will stay here. So, Ms. Reimer, you're not familiar with this, and it's kind of an archaic, old thing, but you've probably heard of a grand jury. You ever heard of that? Well, you don't want to go to the grand jury. And the best thing that could happen is your case stay here, you not get indicted. For that to happen, you need to convince them that you're going to do really well in treatment and get good reports, and that would be this is the best thing either way, whether it goes to the grand jury or not. But that's the kind of evidence that keep your case here and not get you indicted. So come back on October the 10th with a really good report from your treatment. And that can't hurt your case. It certainly could help it. So October the 10th will be the next hearing. There is a waiver till then for preliminary hearing. That'll be at 10 o'clock on October the 10th.
Thanks, Judge.
You're welcome.
State of Ohio versus Karen Ransbottom. Case number CRB 0674. Karen Ransbottom.
Thank you.
Karen Ransbottom. You're Karen Ransbottom?
Yes.
Were you here when I explained rights before, ma'am?
Yes.
Okay. This is an old case, and it looks like you had never been arraigned on it back when it happened, but
I didn't even know I had it. I was running new hires at work, and then my name popped up, so I just come here this morning to make sure it was me, or if it was me.
well, I've got a Karen Ransbottom at 408 Augusta Drive, Huntington, West Virginia, date of birth, Groundhog's Day, 1974.
My birthday's February 4th, 1974, but I'm pretty sure that is like my address a long time ago.
Okay. This complaint alleges that Karen Ransbottom at Fayette Township here in Lawrence County on May the 3rd, 2005, issued a check that she knew would be dishonored in the amount of $225.25 payable to Lowe's. That's been pending since back then.
Well, see, I had
That's a
Gio.
first degree, let me finish. It's a first degree misdemeanor. Maximum penalty is 6 months in jail, $1,000 fine. I've got a copy of the check, and it says Karen Ransbottom, 408 Augusta Drive, phone 304-697-2851, and made out to Lowe's for $225.25. All right. Do you understand the allegation?
Yes.
You think that's you?
Well, I had GL McCorder like a long time ago, and we took care of all this, and I paid everything, but I don't know how this one slipped through the crack or what happened. So
I don't know either.
I really don't know.
It shows that back in March of 2006, a warrant was issued because there was apparently service of a summons by certified mail with, it appears like a signature of a Karen Ransbottom on January 28th, 06 to come to court for arraignment, and then that person didn't show up, you know.
Right.
So that's what the record shows. If somebody took your identity, I've had that happen, where somebody steals someone else's identity, then you should enter a not guilty plea, or if you want to make the state prove the charge beyond a reasonable doubt, which is your right to do, you should enter a not guilty plea.
Okay.
How do you wish to plead to this charge?
Not guilty.
Do you want a lawyer appointed to represent you?
That's fine.
Do you have a job?
Oh, yes.
Where do you work?
Long John Silver's.
Are you paid by the hour?
Yes.
How much per hour?
$16.50.
How many hours a week?
50, 60.
Oh.
I'm a manager.
Well, you're probably making too much money
Right.
for me to appoint.
That's
a
fine.
lawyer.
That's fine.
Unless have you got people dependent upon you for your income?
Well, I have kids.
How many kids do you have?
I have a 10-year-old.
Okay. So there's 2 people in your household, or more than?
Just me and her.
Okay, I'm gonna have to figure out what your income was. What'd you say, 16?
$16.50. I do at least 40 a week, and sometimes a lot of overtime because we don't have no staff.
Okay, I'm gonna go ahead and appoint a lawyer for you right on the edge of
Okay.
where counsel can be appointed. Mr. Morford, I'll appoint you. I'm entering a not guilty plea. And I'm setting cases for pretrials now. October the 13th or after. What's good for you?
Judge, I'm good pretty much any time through there.
Let's make it October 23rd for a pretrial at 10 o'clock.
Your Honor, I'm looking at the court's docket from back then, and I see that she had several cases that arose that looked like basically in the same time frame, and some of them have been nollied, which looks like payment was made. So it might be a matter of the court having missed 1 or 2 back then.
Okay.
So we'd be okay with the same kind of a disposition if she can come up with the amount that's due. There may be more than 1, actually.
Okay.
I see here another one for $50.
On a bad check also?
Yes. 2006, 74.
That's this case.
Oh, I see, I'm sorry, that's the bench warrant. But I think there's even another one. Let's see. (2006) CRB 229. B, because A was dismissed.
Is that the one we did today? Well, that's on, it's got a date for today. Okay, I'll appoint you on that case also, Mr. Murphy. 229B, apparently that file wasn't full for some reason. I'm going to not guilty plea and set it for the same day.
What was the year of that case, Judge?
06.
06, thank you.
So set it the same day as the other case.
Thank you, Your Honor. Has she posted a bond, Judge? I didn't.
She can sign $1,000 or bond.
Okay.
State of Ohio versus Jeffrey A. Trout, case number CRB 21900, CRB 21602.
Jeffrey Trout. This was a case set for a week ago for review. Mr. Trout was not here again. Do you admit or deny that, Mr. Trout?
Huh?
Do you admit or deny you missed your hearing last week?
Yeah, I couldn't make it.
Okay. You just owe fines. Do you have a payment today?
Yeah, it's only 30 though.
Okay, that's fine. Make your payment. I'll set your next hearing for October 30th. You don't owe that much. Get it paid off, or you can work. If you work on October the 7th, you'll get $100 credit for
You said 30th?
October 30th. And October 7th, you get double credit for community service.
Okay.
So you can get $100 credit. You only owe $270.
Yep, I'm gonna try to get it paid up there.
Okay, see the clerk.
Thank you.
Okay, we're going to the jail now for some teleconference hearings.
State of Ohio versus Ricky Carter of the Lawrence County Jail, case number CRA 23582. And Thomas Coe is on deck.
Sir, are you Ricky Carter?
Yes, sir.
Mr. Carter, I'm Judge Capper at the Lawrence County Municipal Court in Chesapeake. That's where your case is being heard. This is a arraignment hearing on an extradition proceeding. It's alleged that there's a warrant for you in, looks like Greenup County, Kentucky. You have a right to remain silent. You don't have to say anything. If you choose to say things, though, what you're saying is all going down on the record. It can be used against you if you admit something about your case. You have a right to have an attorney. You have a right to have one appointed if you can't afford one. And you have a right to bail and to make the state prove the necessary legal things to get you removed to the state of Kentucky. This is not about a charge here in Ohio. It's about a charge in another jurisdiction. That jurisdiction is Kentucky. The allegation is that you've got warrants over there on a possession of a controlled substance, charge being heroin, and contempt of court in that jurisdiction. So they've issued a warrant for you, and allegedly, and they want you returned to that jurisdiction. You have a right to have a hearing here to decide if you're the right person being sought by this warrant, and if I should order you to go to Kentucky on these charges. And you can have a lawyer appointed to represent you. It won't be on whether you did or didn't do the charges, just whether you should go to Kentucky. You can waive extradition. If you waive it, then that means you're agreeing to go to Kentucky. And if you do that, then I will give them a time frame in which they have to pick you up. How do you want to proceed? Do you want to have an extradition hearing, or do you want to waive extradition?
I want to waive extradition.
Okay. I'm going to send a form down for you to waive extradition. I'm going to set bond. They asked for no bond, but I don't, under Ohio law, I don't think I can do that. I'm going to set your bond at $100,000 cash or surety, because these are serious charges. Assuming you cannot post that bond. Is that correct? You cannot post a $100,000 bond.
No.
So I'm going to give Greenup County a week time to pick you up.
Okay.
They're close, so usually that's not a problem with them getting over in a few days to pick you up. So that's going to be, I'm giving them till October 2nd. So jailer is listening in. You can go ahead and notify Greenup County immediately he's available to be picked up.
Notify Greenup County immediately.
So if you're still in the jail, that's a week from today. Next Monday is October 2nd. You should be gone. If you're still in the jail, then I'm going to see you just like I am now, figure out, well, what happened? Something went wrong. And sometimes that does happen. They don't get notified or whatever. And then I'll decide whether you should be released or give them more time to pick you up. But probably a 95% chance you'll already be in Greenup County by next Monday. So they have to pick you up by 8 a.m. next Monday, October 2nd, or on my docket at 10 a.m. Any questions, Mr. Carter?
No, sir.
Okay, we'll send a piece of paper down for you to sign shortly, and then someone from Greenup County should be coming to fetch you in a few days.
Okay, thank you.
You're welcome.
State of Ohio versus Thomas J. Coe, case number CRB 23-128 A and B. Steve Easterling is on deck. Stephen Easterling.
And sir, you Thomas Coe?
Yes, sir.
All right, Mr. Coe, you've got some charges that I'm going to go over with you. 23-128A. Before I do that, let me go over your rights with you. You have a right to remain silent. You don't have to make any statements, but if you choose to, it is what you say is on the record. It can be used against you if you admit something about your case. You have a right to have an attorney and to have one appointed for you if you can't afford one. You have a right to bail, to make the state prove the charges against you beyond a reasonable doubt. Do you understand those things? Let's see, I can see you, but nobody else in the courtroom can, so let me change the view on this so they can see what's going on in case some of your relatives really might want to see you. Okay, I'm just putting, you're all appearing in the, on a monitor in the courtroom. You were on my laptop, but the folks in the courtroom couldn't see you, now they can. Okay, so I'm going to go over the charges with you. 128, case number 128A. It alleges that on February 27th of this year in Fayette Township, you purposely and knowingly and with sufficient culpability for commission of a breaking and entering did engage in conduct that, if it would have been successful, would have constituted a breaking and entering. So you've been charged with attempted breaking and entering. It's a first-degree misdemeanor. Maximum penalty is 6 months in jail and a $1,000 fine. 128B case number, you're charged with resisting arrest. It's alleged same time and place you resisted or interfered with the lawful arrest of yourself. That's a second-degree misdemeanor. Maximum penalty is 90 days in jail, $750 fine. Do you understand these two charges?
Yes, sir.
And you understand the rights I explained to you?
Yes, sir.
How do you want to plead to these charges?
Well, sir, I was just trying to get help on the market areas, just so you understand. That's it.
So you want to enter a not guilty plea? Okay, I'll enter a not guilty plea for you. Do you want a lawyer appointed to represent you?
Yes.
Do you have a job? I'll appoint Mr. Steyer to represent you. Is Mr. Steyer in the courtroom?
I'm here, Your Honor.
This is Thomas Coe. He's got an attempted breaking, entering, and a resisting arrest charge.
So the attempted B&E, I guess, would be an M1?
Yes.
Okay.
They're both, one's M1 and M2. And it is alleged, for information about the bond, it looks like he was released from jail on a medical release back in March in order to come in for arraignment, which he did not do. So what's the state's position on bond?
The state would request a $5,000 cash surety bond.
I'll set that for now. I'll let you talk with him. If you want me to reconsider bond, I'll do that later.
I'd ask to have the jailer keep him out, and I'll step out and call him.
Okay, jailer, if you heard that, his counsel wants to talk to him by phone. Probably should come back fairly quickly then, in case he's going to still be in custody.
I'm available all the upcoming court days until the 20th.
Okay, next Monday, the 2nd.
I'm available, Your Honor.
October 2nd, will be the pretrial at 10 o'clock.
May I take the court's file?
Yes.
State of Ohio versus Stephen Easterling, case numbers TRC 21998 A, B, and C, TRC 202581. Caleb Langdon is on deck.
Stephen Easterling's next. All right, sir, you're Stephen Easterling?
Yes, sir.
Okay, Mr. Easterling, it is alleged you didn't appear for a review hearing on January the 13th of this year, and a warrant was issued because of that. Do you understand that allegation?
Yes, sir.
And how do you plead to it? I'm sorry, I didn't hear you.
Guilty.
Do you have an explanation?
I'm currently living in Columbus, Your Honor, and I was having some insurance issues, so I was going to a program, and then my insurance dropped, so I was able to get to the program to do like the evaluations.
Yeah, you were going to a program called Brightview in Columbus, is that right?
Yes, sir.
Because I had a report from them that I haven't had, that was last fall, the last time I had a report from them. Did you finish up with them, or what's going on with your treatment now?
No, that's when I had lost my insurance.
Okay.
And I was getting a deal with work, so, and I'm on the verge of moving back here, so I'm going to run a program here to get restarted.
Okay, so you are living in Lawrence County now?
No, I currently live in Marysville, Ohio now.
Okay. Well, explain that to me again. I thought you said you were going to try to get in a treatment program here.
Yes, I currently have my school service at work, and I have one more week left, which will be this week, and I'll be moving back here by next Friday.
How did you get arrested on this warrant?
I guess someone had called in.
The police just came to your house, or what?
Yeah, they just.
And was that where you're living now, or was that here in Lawrence County?
That's here in Lawrence County.
Okay. So you're here some, and then you're also, what'd you say the name of the place was?
Marysville, Ohio.
Marysville, okay.
I was here for my son's birthday party.
You got arrested at his birthday party?
No, the day after.
And where have you been working?
I work in the manufacturing plant.
Wow, that sounds like a pretty good job.
Yes, it is.
But you're going to give that up?
Well, I'm going through some family issues with my son and his mother, so I want to come back and be closer to my child.
And he lives here in Lawrence County?
Yes, sir.
Okay. Looks like you did everything else. You paid your fines, you did your community service, you just didn't finish the treatment that was ordered, and you didn't show up for your review hearing. When did you go into the jail?
Last night.
Okay. Can you post a bond?
I don't have the money right now.
Where would you be living locally? If I let you out of jail, where are you gonna go stay?
With my grandmother.
What's her name? Say that again.
Cindy Stacy.
Cindy Stacy, where she live?
She lives in Florida, Maple.
Maple, did you say 409 Maple Street?
Yes.
Ironton? Say take any position on this?
No, Your Honor.
Okay, well, since you did just about you did everything but finish your treatment, I'm gonna let you out on a signature bond. I'll hold you in contempt for not coming to the court, review hearing previously. I'll send you the time served, give you a new review hearing, $2,000 signature bond. Were you to finish treatment, so you're going to go to a facility here locally then now for treatment.
Or if you can recommend one, that would be great.
Well, how are you going to pay for it? You probably don't have a medical card at this point, do you? You have health insurance?
I have insurance right now through the VA yet.
You have through your employment or?
Through the VA.
Oh, you're a veteran?
Yes, sir.
Okay. Well, we have some good veteran services here locally. I mean, it's in Spring Valley over in West Virginia, but it's pretty close by. They've got good facilities and they're very helpful. So I think I encourage you to take advantage of that. And they work with this court pretty closely. So I think the best way to do this, I'm going to get your contact information, I'll relay it on to them. And then have them contact you. What's your phone number?
606-939-3773.
3773. Date of birth?
5695.
What service were you in? What branch?
Army.
Honorable discharge? You have an honorable discharge?
Yes, sir.
You know when that was?
February 2018. I'm not sure the exact date.
And the number you gave me, is that a cell number?
Yes, sir.
Do you have a number for, you said it was your grandmother you're living with?
Yes.
You know her number?
It's 740-302-4025.
And give me her name again, Stacy?
Yes, Cindy.
C-I-N-D-Y?
Yes, sir.
Okay, I'm going to relay that to the liaison for the VA that works with this court. So she'll try to contact you, I believe. They're pretty good about doing that. And then you need to set something up with them. They've got a lot of available resources to help you.
Yes, sir. I will.
And then I want to see you back here on October 23rd.
Okay.
For a review hearing at 9 o'clock, and they'll give me a report then as to what you're doing with them.
Okay.
So you don't have any holders from other courts, do you?
No, sir.
Okay, so you're going to get out today.
Okay, thank you, sir.
All right, so I'll send that information on to the VA. You're getting out. You should hear from her. If you don't, then just call the VA over in over in West Virginia, but I believe she will contact you. She's been very good to work with. So her name is Amanda Rayburn.
Okay.
Okay, we'll see you on October 23rd at 9 a.m.
Thank you, I do.
Ohio versus Caleb Langdon. Case number CRA 23332, CRB 23338, CRD 23672, A, B, C, and D.
What's the verdict?
Thomas Cole will be on that.
Okay, Caleb Langdon is CRA 23332, CRB 23333, PRD 23672. He was deflected to the QRT team. He left, my understanding is he left treatment at Bethesda
Yes.
against advice.
Yes,
After doing that, he overdosed.
yes.
And then wound up back in custody. I'm not really sure how that happened, how he got back in custody, but he is in the jail now with a pretty high cash or surety bond. And Mr. Morford is his counsel. So, and I was not able to be here on Friday. My understanding is Mr. Langdon was not happy with the circumstances on Friday.
That wouldn't surprise me, Judge. His significant other got my cell phone number and sent me a number of texts along those lines.
All right, so how does the state want to proceed? How does the defendant want to proceed? He does have a felony pending.
Caleb, do you want to go back to treatment?
I was hoping to get a continuance to get a paid lawyer to represent me until Friday.
I don't think there would be an objection to that, would there, from the state?
No, and I guess that what he's saying is he wants the case to go to grand jury, so that's what we'll do. Assuming that he'll stay in, or at least there'll be a bond on him through
His
Friday.
bond that was set at $20,000 cash for sure, he's going to stay at that level. So you wish to discharge Mr. Morford then?
Yes.
All right, Mr. Morford, you're released. The bond will remain at $20,000 cash or surety. I'll continue this for a week at your request. Next hearing will be October the 2nd, and you will have retained counsel by then. Is that what you're representing to the court? Mr. Langdon?
What is it, sir?
You're telling the court that you want to hire your own lawyer and that you can do that within the next week.
Yes, sir.
Okay, there'll be a preliminary hearing set for October the 2nd at 10 o'clock, and you will remain in custody until you post bond.
Thank you, Your Honor.
Thank you, Judge.
You're welcome.
State of Ohio recall Stephen Coe. State of Ohio recall Stephen Coe.
Your Honor, I've spoken to Mr. Coe. He gave me the phone number of a family member who thought might be able to post bond. I called that individual. They asked me to call back in 15 minutes to see if they thought they could come up with bond or not, and I haven't had time to call them back yet. So I'd ask to have this called back again after I speak to the family.
All right, it'll be recalled later in the night.
Thank you. May I take the file back? I was copying it.
Thank you.
I'll be right back.
State of Ohio versus Stephen Carmen, case number TRC 22-2038, A and B.
Mr. Stratton's case set for sentencing. I think the first thing to do, from what I see here, is to do a screen today. He's missed screens at many degrees. Is he willing to take a screen today?
Sure. Yes, Your Honor.
Go do a screen and come back, and we can call it after he does the screen. Go, Mr. Cooper.
State of Ohio versus Daniel Hackworth, case number CRB 23538.
Mr. Stratton's case set for pretrial.
Yes, Your Honor. I'd like to set this for another pretrial.
And when would you like to do that?
Your Honor, could we get like 2 or 3 weeks? We'll waive time, of course. Yeah.
16th of October?
Yes, Your Honor.
October 16 will be the next hearing, 10 o'clock.
Just to do something with it, just what I said in the text message. Okay. All right. All right.
State of Ohio versus Nicholas Rouse, case number TRC 23722, A, B, and C.
Your Honor, I'm aware that Mr. Rouse is in the Gallia County Jail, so he is not here today.
Okay.
I am not sure what his charges over there are, but I know that this is not on this case because he has a, I don't know if he signed his own bond or if he posted bond. I don't recall, but.
He has an OR bond here, but I think it's been continued a couple of times with his request. So I'm going to go ahead and issue a warrant in 7 days if he hasn't appeared by then.
Yes, Your Honor.
And Gallia County can just transfer it in.
State of Ohio versus Cody Smith, case number CRB 23210. TRC 22-2099, A and B.
Your Honor, Cody has, I think, a pretrial on the 4th of October in felony court, is that correct? So he has a...
Yes.
You read that? Okay. So I just asked that we set that sometime maybe in the middle of October to see what's happening with his felonies. Mr. Smith represents him on his felony cases.
You know what date he's going back on those?
October 4th. Yeah, the 4th. Are you going to write it
down? October 16th?
Yes, Your Honor.
October 16th for pretrial.
Thank you.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Jamie M. Saber, case number TRD 23-1077.
Amy Saber.
Jamie Saber.
I have Roger Smith.
Yes. Okay, here she is.
That's fine.
Judge, this is a case that I filed discovery. It has been answered. I was out of town when it was answered. I've not had a chance to talk to Ms. Saber. This is our first pretrial. He could come back the 16th or 20th of October. That'll give me time to talk to him. We'll wait time till then.
Yeah, defendant's request case is continued October 16th for pretrial, 10 o'clock.
Thank you, Judge.
You're welcome.
You're welcome.
State of Ohio versus Kevin Browning, case number TRC 23-690, A and B. Kevin Browning. Kevin Browning.
Mr. Smith's case, yes.
Kevin Browning.
I have not seen him, Judge. This is a case, he's been to all the other hearings. We had set it out. The problem was the state was having to find a witness. I understand from Mr. Field, they now have a telephone number. I would ask this also be continued. Given he's been here, I don't know why he's not here. To that same October 16th date to allow the state to get a hold of that witness.
Mr. Hill?
Well, I guess we're not opposed to that.
We've had several pre-trials. He's always showed up. I'll find out why.
October 16th at the defendant's request for pretrial.
I'll notify him, Judge. We'll wait time. Thank you.
Here, you got to do the entry.
State of Ohio versus Matthew White, case number CRB 23576, A and B.
Yes. I don't know if OGP wasn't one or couldn't take him. Well, Bree's here. She can explain what happened Friday.
Yeah, so we weren't able to take him because his significant other is currently in our program and they can't be around each other, but Taylor has agreed to take Matthew into their program.
Okay. And so he's not in jail?
He's in jail in Williams, is what I've been informed.
Williamson.
I was just informed this morning that he's in jail in Williamson.
Okay, yes, and
No, he's not in our jail, he's in jail.
And I spoke to some of those, a post-it note on his file, somebody from Williamson called the treatment center, said they thought they could take him, but weren't sure how they were going to get him, so I'm just getting involved. I assumed he was with Bree's outfit.
Wasn't he in our jail last week?
Friday.
Yeah, he was only supposed to be released to OVP,
That
so.
was why I'm unaware of what's going on today, pretty much.
Yeah, let's recall this and check, because that sounds We would have had to do an extradition.
Yeah, I don't know what's happening.
If
we could, Judge.
Have the clerk check it and see.
Thank you, Your Honor.
State of Ohio recalls Stephen Carmen, case number TRC 222038, A and B.
All right, he has a good screen. Sorry, Your Honor. Okay, so it sounds like from the report too, there's still stuff remaining to do.
Yes.
So continue this case for another month,
Yes, Your Honor.
October 23rd.
Yes.
October 23rd will be the next hearing for sentencing.
All right, good to go.
Thank you, Your Honor.
State of Ohio recalls Thomas J. Coe at the Lawrence County Jail, case number CR 23128, A and B.
Your Honor, I've spoken to Mr. Coe's family. They believe they could meet a bond of $1,000 cash or surety, which, recognizing that a cash or surety bond is appropriate due to the alleged failure to appear, I believe that even a lower minimal cash or surety bond would still ensure his appearance. So we would ask for the bond to be set at $1,000 cash or surety. And then once I have an amount, I will contact Mr. Sowers and give him the family member's phone number.
Mr. Hill.
Your Honor, based solely on the affidavit that's been filed with this case, it appears that there might have been more going on than just somebody trying to break in somebody's building, that there may be some other issues going on that led to that behavior. So him being out without some other assurance that he's going to be under control and not do things like this going forward, I think would be very important. So I don't know whether there are issues related to substance abuse or mental health that might be involved here, but if he's going to be out, if he were going to make a bond, we would want the condition that he be supervised in some way, or at least assessed for that.
Well, Your Honor, you already asked for $5,000 cash or surety. I'm not sure I understand why that would do more to protect the concerns he's now raising than $1,000 would have. So I'm going to ask for $1,000 cash or surety bond. We're only setting a week, getting it back in here, and if at that point we want to look at, if he wants to make some type of an offer that entails that sort of an assessment, we would agree to that. But I mean, I don't know enough at this point to make that kind of a call, and I can't have fully frank conversations with my client over a recorded phone line. So at this point, our motion is for $1,000 cash or surety bond.
I'll just ask this, is Mr. Coe under the care of any medical providers currently?
Sir, do you have a doctor?
Just do OVP Ashland.
I'm sorry?
OVP Ashland, is that what you said?
Okay.
All right, I'm going to divide the baby in half, like Solomon would do, make it $2,500, with a further order that you continue with your treatment at OVP. So I'll reduce the bond from $5,000 to $2,500, with also an order that he continue with treatment at OVP as a condition of bond.
Thank you.
And we'll just keep that date of October 2nd.
All right, thank you.
You're welcome.
State of Ohio recalls Matthew White at the Lawrence County Jail, case number CRB 23576, A and D.
need Roger Smith. Counsel. And I think we need Taylor too, right? Matthew White.
Oh, what son's getting ready to find out?
He's in our jail.
Okay, well, Williamson came about because I got a post note, there was a treatment facility in Williamson, which I thought was kind of weird, but said they could take him, and I was exploring that, but if Taylor can take him, he's in our jail, I think that makes more sense to me anyway.
Yes. Mr. Healy.
We're not opposed to that. When's that set to come back? Wasn't there already a date?
It was on 10/2.
10/2, but we had thought that he was going to be going to OVP, but they didn't want to take him because his girlfriend was there.
Yeah, we just want to come back sooner to see the situation.
Yeah.
So I'll change the order. Order that Matthew White be released only to Bethesda for treatment, and then we'll keep that October 2nd date for a pre-trial.
Perfect.
I'll
So
get him to.
you can pick him up today?
Yes, Your Honor.
He'll be picked up today, released to Bethesda.
Thank you, Judge.
Thank you, Your Honor.
I don't see this, that city that was on there about Williamson.
Oh, there it is.
We don't need Matthew White at jail.
I just let them know.
Okay.
State of Ohio recalls Matthew Fortner, case number TRD 162079, TRC 162056. Matthew Fortner. Matthew Fortner.
He's at Bethesda. This was set on the docket today for review. Is he inpatient or outpatient?
He's outpatient, and he's also monitored through Common Pleas. I think he's nearing close to graduating.
Okay.
Your Honor, I had a note that he was supposed to do some community service. He was ordered on 8/21 to have something done before his next meeting, and he has not showed up for community service.
What do you say about that, Mr. Fortner?
Yeah, I told you I'd try to get it done that Saturday, and I just been working a lot on the weekends, and it's hard for me to get it done throughout the week. I take my kids to school, and it's just hard for me to make it during the week. And
Are you working?
oh yeah,
Where are you working?
McMillan Roofing.
Okay, you still have 24 hours of community service to do.
Yeah.
When can you be here?
We ain't got no Sundays, huh?
The Lawrence County Animal Shelter's 24 hours a day, 7 days a week.
You can work at the dog pound.
I can be there Sunday.
Okay.
That's in Cold Grove, right?
Yes. Okay, October 23rd will be your next hearing.
Okay. I got a question, Your Honor.
Yes, sir.
It said I had a holder here from Lawrence County for my license. Can I get that released so I can try to get my license back?
Go talk to Mr. Major about that. I don't know what that's on. Probably for an unpaid ticket or something. But he can pull up and let you know.
All right, thanks, sir.
State of Ohio versus Douglas Price, case number CRB 23276. Douglas Price.
This is Mr. Thompson's case. Mr. Thompson still here? Anyone seen Mr. Thompson?
He was definitely here earlier, but
Yes.
Mr. Thompson's no longer here, Your Honor.
All right, Mr. Price, you had a hearing on September the 18th, it's alleged you failed to appear. And you're supposed to be going to Bethesda, is that right?
Yes, sir.
Are you?
I haven't made it there yet. That's why I was here actually last week too. She came in, was trying to talk to me, so I left because I'm not supposed to be around her, but,
Okay, go talk to Taylor, and then what she says will decide whether I lock you up or let you go. So go talk to Taylor from Bethesda, and we'll have you back.
State of Ohio versus Allison Chapman, case number CRB 23585.
Mr. Smith's case. Set for pretrial.
Yeah, as far as I'm concerned.
Your Honor, I filed for discovery on this matter. I think we're going to review it. It's a theft case, and the state offers the typical treatment for the first offense. So after I review it and I talk with my client more, maybe we can have it resolved in the next pretrial.
When you want to come back?
A couple weeks will be fine, Your Honor. Just
What
whatever.
about the 16th of October?
That's fine.
October 16th will be the next pretrial at 10 o'clock.
State of Ohio versus Tanya R. Gentry, case number CRB 2374. Tanya Gentry.
She's on teleconference. And this is Tyler Smith's case.
Your Honor, this is the same as the last case. I filed for discovery as well on that one. So if we can set for the 16th, so I can review it, and I can talk with Ms. Gentry before then.
I actually have a question. Is there any way I can actually withdraw my plea and change it to guilty?
Well, that's fine. It's the theft case. I'll let the prosecutor say what the recommended sentence is.
Your Honor, if she pleads guilty, we would recommend a suspended jail sentence of 10 days. Is it 5 days of community service that is typically ordered? A fine of, I don't know what the court normally would do on a case like this, but we wouldn't take any position on the fine. And in order to stay out of Walmart.
And Ms. Gentry, are you you're in a treatment facility in Charleston now, right?
Yes, sir. I'm currently with my case manager right here.
Okay, and that's at Ray of Hope?
Yes, sir. I'll be 4 months going today, and I'll be here for 3 months on the 10th of this month. I'm an employee. I'm on attending regular meetings as well.
Okay, very good. And I do have a report from that facility from August. Okay, anything else you want to tell me, ma'am?
No, sir. I mean, it would be awesome if I could just not go to jail though. I would be willing to pay the fines and do community service. But going back to jail honestly would not be good for my recovery.
Okay, well, I kind of agree with that, Jill. is a place to be avoided.
She might have was she in jail in this case at all?
I don't think so.
No, sir.
She appeared, I think initially, she was already in treatment, I think, when she did appear. Is that right? You initially missed the first arraignment, but then you came later.
Yes, sir.
Okay. So here's what I'm going to do. I'm going to go ahead, I'll accept your guilty plea. Since you're in treatment, I'll reduce the fine to $25 since you don't have much money. We'll order you to pay the court costs. I'm going to make it 30 days in jail, and I'm going to suspend all of it on the condition that you complete your treatment program at Ray of Hope.
Yes, sir. I have to wait January 10th.
Okay. I am required you to do 5 days of community service, and you can do that at any legitimate charitable organization, or you can do it here at the court. We have a community service program here at the court, but as long as you're living out of town, you can do it for a charity.
Okay, how do I get the reports back to the court? Like, I'm not talking right now. How can I get it back to you?
Well, we will accept regular snail mail, we'll accept faxes, we'll accept email, we'll accept hand delivery. So those are the usual ways we get reports.
Okay, sir. No problem.
But it needs to be on a letterhead, not written on the back of a napkin.
Yes, sir. I'll have my case manager do that for me.
Okay. I'll set your first review hearing for November the 6th. So you can appear by teleconference then. It'll be at 9 a.m., just like you are now, and then get me some community service in here, and eventually you'll have to pay off your fines and costs, but I'll wait on that while you're completing treatment, and I need a report saying you completed treatment.
Yes, sir. That's no problem at all.
And here's the worst part. Are you ready for the, I said, here's the worst part of your sentence.
Okay.
You have to stay out of Walmart.
No problem at all, sir.
Your order to stay out of Walmart.
Yes, sir.
Okay, November the 6th, 9 a.m. is your next hearing.
Okay, thank you so much, sir.
You're welcome.
State of Ohio recalls Douglas Price. Case number CRB 23276.
Okay,
He's going straight from here.
okay. To inpatient or assessment?
To get an assessment.
All right. And then let's come back pretty quick then to see where that left us. October 6th. will be
They're going to text me the moment he shows up right here on County Road 1.
Okay. October 6th will be your next hearing. Sir.
Thank you, Your Honor.
10 o'clock.
State of Ohio versus Jerry L. Cheney Jr. Case number CRB 23493.
Mr. Steyer's case set for pretrial.
Your Honor, this matter involves an incident that allegedly took place in the Walmart parking lot. Walmart provided, I guess, an electronic document that purported to be the cameras to the footage from their cameras to the Sheriff's Department. The Sheriff's Department was unable to open them. We've asked to have the Sheriff's Department forward that on to the prosecutor's office to have, let Detective Lehman take a crack at them, and also give them to me. Let me see if I can get them open, because if we can see the video, that would probably shed a lot of light on what may have happened that day. So at this time, we're going to ask for a continuance. I would defer to the state on how long they think they need to get that information together, and then we would waive time constraints to accomplish it.
Mr. Hill.
Oh, I don't know, maybe 3 weeks.
That's the 16th.
I'll look at September. That confused me for a second. I'm actually on the docket that day anyway, so that would be a great day.
October 16th will be the next hearing for pretrial, 10 o'clock.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Edward Davis, case number CRB 23570, A and B. Edward Davis. Edward Davis.
Mr. Stiers, please set the pre-trial. Edward Davis.
Have just a moment to speak, Mr. Hill.
assessment and get some reports to me. And every month give me a report of what's going on to prosecute. Can't be dismissed. They don't just dismiss it outright. Dismiss them with the right to refile. Hang on, let me get this recalled.
Your Honor, can we have this matter recalled?
Yes.
I'd like to have a chance to speak a little more extensively.
Case will be recalled later.
I'm going to talk to you again in a minute.
State of Ohio versus Vilma Gargalier, case number TRC 23-1297, A, B, C, and D.
Your Honor, this matter is an OVI exploring the discovery possibility, looking to see if there's any issues that might be right for suppression. So at this time, I'd like to just continue the matter to a date convenient to the court, and we would waive time constraints to accomplish that.
That 16th date to
That still works, Your Honor.
October 16th for pretrial, 10 o'clock.
State of Ohio versus Buddy L. Hardy, case numbers TRC 23-532, A, B, C, and D. CRB 23287, CRB 22600, TRC 1870, and CRB 1864.
Light on my feet.
Mr. Stiers, please.
Do you have this now on restitution?
Yeah. $50 deductible.
Okay. And so your offer on this was
60 suspension.
which one? No. We'll do it for
This is a second and 10 plus a refusal within 20. So he's got jail time. Plus this other thing was unacceptable too.
That's the restitution for the window is $50. So that's what we're going to do. The second was a refusal with additional. That's 20 years jail. I'll try longer. So I don't want to do that. To do that. You see, I'll try to come longer. And then, do it like your time.
I'm sorry, you said
You got what? I'm sorry. Go ahead.
when I talked to you, you said I wasn't going to go to jail.
I'm trying to get.
There's no way I'll be able to keep.
Well, hang on.
I'll be homeless if I go to jail.
Okay, don't,
Like,
slow down, slow
I've
down.
been paying y'all for 3 years.
Slow down, slow down.
I made a mistake. Let me, come on, man.
Your Honor, could we continue this matter one more time? Let me talk to Mr. Hardy a little further and see if we can come up with.
Yeah.
Thank you.
16th also?
16th will be fine, Your Honor.
Okay. Defendant's request, case is continued October 16th. Another pretrial.
I'll come talk to you in a minute, don't leave, okay?
I'm able to get the job.
Just go out there and I get you. Go out there and I'll talk to you in a second.
You ready?
State of Ohio versus Gavin Montgomery. Case number TRC 23937.
Mr. Dyer's case for pretrial.
Your Honor, I filed a motion to suppress regarding the stop in this matter. The state has looked at that but wants some further time to investigate a couple issues that I raised in that, I believe. I don't know if the court would prefer to go ahead and set it for hearing or set it for another pretrial on the motion. I leave that to the court's discretion.
Okay, probably pretrial. But the 13th, are you here then?
The 13th, I'm sorry. I don't know, hang on, it's a Friday. Is that okay? Okay, yeah, the 13th would be fine, Your Honor.
October 13th, be the next hearing. 10 o'clock.
State of Ohio versus Stevie R. Ward, case number TRC 23922, A and B. Stevie Ward.
Your Honor, Ms. Ward, this case is an OVI with a urine screen. My understanding is that the state has called and the urine screen is still unavailable, so I would leave it to the state what they wish to do.
Well, we need to continue it. Now, it's
What's
also...
our timeframes?
They told me it might be back in a week.
Okay, they told us that the results will be back in a week. I don't know what's happened to the file. I had it this morning.
July 9th is the date of the...
There have been
subject.
time waivers. There's,
Have there been?
it's not here. I don't know what.
I believe we've only been back once since the original
That's correct.
hearing, and there's not been a waiver at this time.
So October the 17th would be the 90 days. So it's getting close. We need to come back before then, obviously, and we've been told that the results will be back in a week. The other thing is that I understand that people from the Common Police Court, Drug Court, were here today on her behalf, which speaks highly of her.
Yes.
So,
Sorry.
well, this is before I got here this morning. I had Mr. Anderson covering for me because I had something else I had to take care of. And it's my understanding that she's doing successfully in drug court. So I don't know whether they have some feeling about how the drug results are going to come out on the drug screen or not.
We do, Your Honor. She is a participant in the Nexus, I'm sorry, the Nexus recovery docket in front of Judge Ballard. I've spoken to April and Josh from the recovery docket as well. I've spoken, doesn't look like she's here right now. Oh yeah, she is. Charlotte actually came in here today from Mended Reeds as well on Ms. Ward's behalf. She was here last week as well, but we had already continued the case due to the lack of results. It's my understanding that she is tested as part of her treatment that's ongoing as well as part of her participation in the drug court, and has tests on both sides of this alleged event that are appropriate. So we are confident that the test results are going to come back clean, but obviously they're not here yet.
Okay. 6th or the 10th of October.
Let me take a look at my calendar, but I believe the 10th is a little better for me just in terms of the caseload, so, but either one's fine.
Okay, do the 10th. That gives the state enough time if they're...
It should, Your Honor, hopefully.
Okay, October 10th for pre-trial, 10 o'clock.
State of Ohio versus Thomas Gee.
Thank you.
Case number CRB 23480.
Mr. Lambert, you're going to be representing Mr. Gee?
Yes, Your Honor.
So we're going to need to talk with her. And is this mine copy of the key? Yes.
That's pretty good.
Do you know when this conversation took place? Well, I see this says 9/12, so. Okay. You were going to continue this. We have a secretary to move it, but you decided not to. It's all right. I don't know what else to do today. Well, anyway, yeah. I'll talk to her. See her now.
October 6th. It's 2 weeks. This Friday.
I wonder how this took so long to get arranged. It's supposed to have happened back tonight.
No, you just got the papers. Give us some days.
Okay.
I'll make it a serve.
Okay.
You ain't got any problems.
You say you want to come back on the 6th?
Yeah. Your Honor, can we reschedule the pretrial for October 6th? I had some information I gave the prosecutor they need to check with the victim on.
Okay. Defendant's request case continue October 6th for another pre-trial, 10 o'clock.
State of Ohio versus Deshaun J. Hannah. Case number CRB 23565 A and B.
Judge, this is an M4 failure to control dogs. Excuse me, getting over a cold. I talked to the state this morning. There was another defendant on this. The state needs to investigate that defendant a little bit further to determine whether to proceed against my client or not. So we would find signing time waivers and coming back in approximately 15, 20 days to allow the state to conduct their investigation.
There is another individual, and she's actually listed in the affidavit, but there was no separate affidavit. They only sent us information to charge Mr. Hannah. This is actually a very serious case involving a real injury to a human being. But it may be that the responsibility for this is with Ms. Webb, the other person. So we want to make sure we got the right person.
How about the 23rd? 16th already pretty full.
I'm in Sida County in the morning, Judge.
Okay. 27th,
Let's do it.
October 27th for pre-trial, 10 o'clock.
You're good, man.
State of Ohio versus Virgil Petty. Case number CRB 23554. And case State of Ohio versus Paul J. Petty. Case number CRB 23553.
Mr. Morford is representing Virgil Petty, Paul Petty, my understanding was hired counsel.
I'm talking to Chris DeLauder. Had to mix up at work with my pay. Had to wait. I get paid tomorrow. And I'm going to have a meeting with him later this week, sir.
Okay. Mr. Morford, how do you want to proceed?
Judge, I don't care to continue it until this man can obtain Mr. DeLauder or other counsel.
Your Honor, this is a cross-filing between, I believe, brothers. And just my feeling from looking at the situation, it doesn't look as if there's one of them that has some sort of a power advantage over the other or control in the kind of way we see in domestic violence situations among romantic partners. So I don't know whether these fellows would be agreeable to doing a 90-day continuance and to dismiss the charge with payment of one cost if there's no further problems.
I agree.
I'll agree. Okay. Everybody's on the same page. So what I understand, we're going to go a period of 3 months if there's no further problems. There'll be one court cost paid between the two cases, and both cases will be dismissed. And everybody's agreeable with that?
Yes, sir.
Mr. Morford?
Yes, Your Honor.
All right. December 22nd. Be the next team. Who's gonna, are y'all gonna split the cost, or how are we gonna do that?
50-50, sir.
Okay. And will be assessed against which case? Who's gonna collect?
I will.
All right, so it will be assessed on Mr. Paul Petty's case. So here's what I'm also going to do, since we've agreed to this. You don't have to appear on December 22nd if the costs have been paid and there's no further problems. If there's been further problems, or there's, that you'll be notified by the court or someone, then you have to appear, or if the costs aren't paid, you got to appear. So pay the costs, no further problems.
Can I get a total, sir?
It'll be $135.
Is that the 22nd of December, Your Honor?
Yes, sir.
So we'll need a time waiver. Which one's your Virgil? Yeah.
You're just waiving your speed trial rights because we're going to go 3 months to see if things get dismissed. Otherwise, we can set it for trial sooner than that.
They're in agreement, sir. Thank you, Mr. President.
Okay, anything else?
We'd like them to know also if there are further problems, we need to know about them. We hope there aren't. But if there are, then we can come back sooner.
State of Ohio versus Marissa L. Short, case number CRE 22623, CRE 22624.
May I approach, Your Honor?
Yes. Sounds like there's still stuff to work on.
There-
Progress, I would say progress, but with still things working on.
We'd agree, Judge.
So-
Your Honor.
Yes.
If I may, I was brought to my attention this morning a situation where Ms. Short went on pass, returned late to Bethesda from pass. Her parents asked her not to take a car, and she took the car anyway and has no insurance. So I don't know.
She'll be locked down for a while.
She's going to lose pass privileges, and I'm okay with whatever consequences Bethesda sees fit.
I wasn't aware of it until this morning. So.
Okay. And did they get the car, is their car, I'm assuming?
Yes, she returned from pass. The way our passes work is that they have to have driver's license, all that stuff is verified where they're going to be, and they have to remain with that person where they say they're going to be. If they don't do that, then they lose pass privileges.
Okay. Well, I'm not sure how you would get away with taking your parents' car when they said no. I'm going to go out on a limb and say maybe that problem started a long time ago. When somebody owns a car and they say, no, you can't take it, that means no, you can't take it, even if it's your parents and you're used to them giving in to everything that you want to do. I don't need to hear anything else. Ma'am, don't raise your hand. When you're living at someone else's place or visiting them, you have to do what they say. And you're not a kid anymore, right? You're a grown woman. So you can't take your parents' car just like you couldn't take my car. You take my car without me giving permission, there's going to be a problem with me, and then if you get away with it, you're going to have the police after you. So you got to do the right thing. Start honoring your parents like they're real people, not just people that you get to boss around, tell them what you want to do, when you want to do it, how you want to do it.
Your Honor, we have also made some changes to our treatment plan. She'll be on my caseload from now on, so.
Okay, I think that's a good idea. Okay, let's come back on October 23rd for your next hearing. That's all.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Melissa Snell, case number CRA 23224, A and B.
You did.
Thank you.
Your Honor, I spoke with her counselor this morning. There was some incidents where there were some addictive behaviors that started to pop up. She is compliant now, but we are still addressing those.
Still got stuff to work on.
She's been compliant with deflection.
Okay, very good. We'll keep, that's what this is for, work through this stuff, make progress. It sounds like you are, but you still have stuff to do.
She looks better and she's got a smile on her face today, Judge.
Absolutely. Okay, October 23rd will be your next hearing at 10 o'clock.
Thank you, Your Honor.
Thank you.
State of Ohio versus Charles and Michael, case number CRA 2312.
It would be Mr. Well, I think this is, maybe not. Okay, it is Mr. Scott's case.
Yeah, sorry about that, Judge. Yeah, this is a F5 drug case. This has been going on for about 5 months. He's been in treatment, RSS. We had a report from last Friday that was pretty outstanding. So based on that, my client's progress, we're actually going to present it to you that he goes to the QRT, dismiss here, and receive treatment that way.
Is that agreeable with QRT?
Yes, Your Honor. I met with him earlier before court, and he did agree to all terms and conditions.
Okay, so one thing I want to make sure you understand, Mr. Michael, and we've had this happen when people don't comply, then your case is going to go directly to the grand jury for an indictment. You understand that? You won't be coming back here, you'll go down to the other court.
Right.
But you don't want to do that.
No.
Okay. All right, be dismissed, and you're on board with that, Mr.?
Yes, Your Honor.
Dismissed to QRT, or deflected to QRT, I guess would be a more appropriate term.
Thank you, Your Honor.
Okay, good luck, sir.
Thank you, Your Honor.
There you go.
Thank you, buddy.
Absolutely. Stay out of trouble.
Okay.
He's going to give you my phone number.
Did she?
State of Ohio versus Tracy L. DeMint, case number TRC 22545, A, B, and C, TRC 202272, A, B, and C, TRC 213522, A, B, and C. Tracy DeMint, did not check in, Your Honor.
I wanted to let you know, I spoke to him earlier to tell him that he had to court. He said he had spoken to his lawyer and told that he had an appointment at the hospital today. Yeah, I have a report.
He has a colonoscopy scheduled for today. He is compliant with all, hang on, I'm so sorry.
Judge, we contacted my office earlier today and forwarded to one of my assistants a text that appears to be from SOMC saying that he has a medical procedure today at 1:45 p.m. He's asked that we continue it to Friday.
He's had a complete turnaround since the last court date that we were here. He's been very compliant. He's been very motivated to help other clients. I mean, since the last, when he was here last, I think he was threatened to go to jail, so I think, yeah.
Okay. Based on your say-so, to me, 1:45, he could have come here and still done that, but I'll give him a break. And I don't understand when they say, well, we're gonna schedule you for September 25th, when they say, sorry, I've got to be in court that day. I don't get that either, but I'll continue it for 1 week at his request, and I'm assuming the state doesn't object.
I'm not opposed to it.
To October 2nd for sentencing.
Thank you, Your Honor.
You're welcome.
Thank you, Judge.
State of Ohio versus Brandy M. Hines, case number TRC 23182, TRC 222783, A and B.
Mr. Morford's case for sentencing, she's at Ohio.
Judge, may I approach?
Yes.
I have a report from my husband. Report.
It's a good report. How's the state want to proceed with this?
They mentioned progress, which is good. I don't know if it's to the point where we could consider her have been fully compliant to completion, so we'd like to have another hearing.
Judge, when you select a date, could you make it a Monday,
Yes.
please?
October 23rd. For sentencing.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Laron C. Beach, case number CRB 23162.
This is Mr. Collinsworth's case set for sentencing.
Can I have Rich Herman?
Yes.
So you don't want the protection.
So he's completed Bethesda and he's got good screens.
And our victim, Ms. Williams, is here and doesn't want a protection order anymore.
Are we ready to wrap this up, or how do you want to proceed on it?
He's completed, and that's very commendable. Hopefully it's a permanent change.
Excuse me.
Now, he pled guilty before, so this is sentencing.
Yes.
And we are,
Please, June 26th.
we are not opposed to a suspended jail sentence at this point.
Mr. Smith, you ready to proceed?
Yes, Your Honor.
Include things? And name your Caleb Williams.
Yes.
Do you have anything you want to tell me before I sentence Mr. Beach?
No, sir.
Okay. And you don't want a protection order?
No, sir.
You all, well, I guess it's none of my business. You intend to be around each other in the future, or?
Probably not.
Okay. But you're not asking the court to impose any particular sentence then?
No, just what we agreed to.
Okay, what was that?
I believe it was just the counseling, and I think they had said anger management.
Okay, he did finish that. I've got a report saying he finished that.
When we first started this case, we felt that it was serious enough that we're going to recommend jail time. But then Ms. Williams availed upon us to allow him to do this counseling. And if he were successful, then we would agree that we would not have to recommend actual imposition of jail time. So we're okay with suspended jail time.
Okay, anything, Mr. Smith, from you or Mr. Beach that you want to say to the court?
Your Honor, I don't have anything on behalf of Mr. Beach, other than, the fact that he has successfully completed anger management, which is what the state was looking for, and I believe that Ms. Williams was looking for, so he's done that, so we'd ask that any jail time would be suspended.
Anything you want to say, Mr. Beach?
No, sir.
Okay. I'm going to impose a $200 fine, order the cost be paid, 15 days in jail, and I'll suspend all of it on the condition there's no further issues, no protection order at this point. That's at her request. I'll make it level 5 probation for 2 years, which means it's non-reporting. I will set a review hearing just to make sure you pay the fine and the court costs. And that's going to be March the 25th of next year. Of course, if there's a problem, ma'am, you can report it to probation or the police.
Okay. I'm sure there won't be.
Okay, very good. You'll need to go check in with Mr. Major.
Thank you.
About his probation. Pay it off before March 25th. You don't have to show up for that hearing.
Okay.
Thank you, Your Honor.
You're welcome. That's all.
State of Ohio versus Kara Herman, Case number CRB 2381.
Mayor Hearn, is Mr. Stratton's case set for simple?
As recommended.
Yes.
Doing very well, Your Honor. I know she's been in the program 3 months. How much longer does she have?
3.
3 months. 3 months longer. I know she's missing her boy a lot, being home. And
Getting some visitation there now, or?
Getting some, yeah.
yeah,
Your Honor, she is in deflection. She's been compliant. She showed up to all weekly meetings. I will say that I've seen a huge change in Ms. Hearn. I think she's doing extremely well. We would ask, as far as deflection goes, I think it would be okay to move her back to once a month check-ins. If that's okay with the court.
Yes. Okay, and I agree with what Megan said about how well you're doing. I just noticed a difference in the way you carry yourself too. So you seem more positive, and I've just noticed a big change in you. And I want to applaud that and hope that it continues. I think you're on the right path.
she is, Your Honor. She did want me to ask whether that she can go to outpatient. I told her I would ask, and I would bring it to the court's attention.
I'm getting the no from both sides, I think. That's what
Yeah.
I think we need to do, you got a lot invested, but it's not that, it seems like a long time, but in comparison to what the end result can be, I think it's worth investing the time into.
Yes.
Either one disagree with that, or?
No, I think she needs to complete the program. We've taken her out of residential before and put her in outpatient. It's never worked out to her favor. She will get 24-hour visits and 3-hour passes as we continue to progress, but I'm opposed to the transition.
I agree with Bethesda.
Okay, very good. Let's, October 30th?
Yes, Your Honor.
16 October 30th, 10 o'clock.
Thank you, Your Honor.
Thank you. Your Honor, may I ask a question?
Yes.
As to the previous case with Marissa, can we move her to once a month check-ins as well?
Yes.
State of Ohio versus Kyle Davidson, case number TRC 23764. Your Honor, this was set for noon trial. It's not yet noon. Mr. Stratton informed me that they may not have to go through the trial. I'm not sure.
Mr. Davidson here?
No, he's not.
No, he has not checked in, Your Honor.
Okay, well, we should wait until noon then. Let's go ahead and do some of the other cases. We'll come back to this. It's only 10 till.
Ready.
State of Ohio recalls Edward Davis, case number CRB 23570 A and B.
Mr. Steyer's case, set for pretrial.
Your Honor, this matter is a pair of M4 domestic violence charges. The state had proposed, and we were agreeable initially to a 90-day continuance with a mental health assessment. However, due to the nature of his employment, he is laid off while this charge is pending and will not be able to return to work while the charge is pending. I raised that to Mr. Heald, and he sagely came up with the idea of a nollie at this time with the right to refile, with an agreement that Mr. Davis will go ahead and seek the assessment we discussed and follow-up care, report that to me, which I'll then report to the prosecutor, and should there be either further problems or should there be an issue with, he doesn't go and do the assessments, I've made it very clear that has to be done, that at that point the case could be revived and we would have no objection to that at that time. So we are agreeable to that if that's what the state's willing to do.
Before you call me a sage, I'd forgotten about the fact there's a protection order, and even though I believe that our victim would be in complete agreement with the rest of it, we still have the need for a protection order. So what I would like to do, if we may, is have a chance to speak with the alleged victim. One thing about, there's two victims. They can get civil protection orders. I also realize that it's time sensitive since Mr. Davis apparently can't work during this time. So perhaps a call or two could be made here even this morning if Mr. Steyer had some time.
I'll stick around.
And if
We'll
Ms.
recall this
White
later in
has
the
some
docket,
time.
let the state try to get a hold of the complaining party to see if they agree with this.
Thank you.
State of Ohio recalls Betty Ross, case number CRB 16530. Betty Ross. Betty Ross.
Your Honor, if I may, Mr. Sauer said he talked to her, and she said she had got about 40 days, she was going to be.
She's not here yet. Is that all we can do?
Yes, unless Mr. Cremings has a motion to suppress, and I'm not sure if he's ready to proceed or not.
I don't know that my client's here just yet, Your Honor. I think it was scheduled for noon.
Correct.
Is the trooper here?
Trooper is here.
Okay, we're at an impasse then on things to do, so I'm going to take a recess. Heather? She said she had a report on it.
Yes, sir.
Did you say you had a report on Tina Hammonds?
I do.
State of Ohio recalls Tina Hammond, case number CRB 13538.
Hammond, there's no S on it. She's at RRG. Got a report. Okay, so very positive report. She didn't show up today. So I'll continue it. And you can let her know she needs to get in. I'm going to make it October 13th.
Thank you.
Do you know if she's wearing an ankle monitor? I had a note about that, but I don't know for sure that it got placed.
I don't know. No idea.
Okay, I'll continue it to October 13th.
Nine AM?
Yes.
Thank you.
Okay, court will be in recess. I can be Ms. Gabbard and Mr. Elkin as well. We're on recess.
Always wait on my client. Always. You always do something wrong.
stage is nice from there.
Douglas Price did not show up. Yep, call me, text me. Douglas Price. I'm trying, he's never called me. We're just standing over there in here. She's on your special.
Too much effort.
She even has her sense of humor.
Is he supposed to go back
One of the
there?
opposite.
Okay, I have. That's okay, I got it.
She said he found his humor.
I'll be right there.
I ain't down there, but I'm
I told you, I kept texting my brother. I told him, I said, I suggest you keep in mind I work for the prosecutor's office and our communication is not privileged anymore. Just because I never terminated him from the program, he wouldn't stop calling me. I was like, listen, I work for the prosecutor, stop calling. It's going to be easy. It won't be.
He needs to be on term somewhere far away.
And he thought that if he got in with Jeremy from RPM and went to work, Jeremy scheduled him to set up this morning to be picked up, and he still didn't show up. Why call us? Why waste your time and our time if you're not going to go again for the third time?
I can't wait for the Captain Price to show up.
They are dirt.
I wish that I could cure every problem.
And as Mr. Scott will tell you, people have four ways.
Yes. Know that.
The light was falling here and the girlfriend's falling off, and now he's going to wait. I'm like, no, he's not.
Yeah, I think it's actually his wife that's at ODP. I'm not sure. I'm not sure her name. He just told me that he's
Wow.
He's always such a wreck when he comes. She said, so she has these two black eyes, it's Ashley, because he's so it's his wife.
So how's she calling Ashley?
I don't know, I just want my case management or something, but she had two black eyes and said he was the one that done it, and they're like, you need to get away from him. She's like, well, he was fighting his women, it happens sometimes. It's the man, it's not actually him. I'm like, what are you gonna do when he kills you? He was fighting his women.
Well, yeah, that's what he was joking things.
Yeah.
Oh, wow.
Jeez.
When you have a word for it,
Yeah. He was fighting his demons.
I don't know.
Okay, I did.
Listen, Caleb is the best, right? I wonder who's over there.
No, she wasn't calling us. What are you talking about?
And she harasses,
She's in prison.
and he's cute.
So I figured out that
He's
I
coming back.
can actually download,
Mr. Morford, Dad.
I can actually download the videos because I have access. No.
Yes, but I don't remember what happened.
So when I started to do it, it said,
probably on the
This is too big for your.
She's in there. I told her I'd seen her.
And she, it's high maintenance. I talked to her this morning, I talked to her on the phone. She says,
yeah.
oh, go ahead, I'm so
Oh,
sorry.
nothing, it's just,
Did they pull this case up when I was talking to these people? Because that victim's out there. I think,
30 seconds, ladies, 30 seconds. 30 seconds to get here.
that one,
oh, Gray, I thought, he said they did. Okay, so we can go ahead and do it backwards and drop the charge on him as long as we actually confirm he did the counseling.
Yes, we're gonna set a date at which he
And
needs to
then
turn it into.
they still
Okay.
want a no contact order, but I gave them information about a CPO.
Okay,
And they said they'll take that route
okay,
in order for him not to lose his job.
okay. Well,
Because I said, well, she said, they said,
got the
well, we
flash
want
drive?
it kept. And I said, well,
I'll go ahead and get it set up for you.
so, wait a minute. Are these, have we done?
they're still in front of me.
Oh, we're doing a motion hearing now.
I guess.
We're doing it. So I wonder if we're doing this. Check on these.
Hey, look what I found.
Don't.
It's because Martha already says.
There you go.
Thank you.
Yeah, I got one guy.
Should be on the floor, right?
I want to check on this.
I tell you, he's very, very, very ill. He has 3 different types of cancer. He didn't be a felon, so. He signed terms and conditions and stuff. And he's with RS, so they're gonna make sure he has a right to check in and all that kind of stuff. Marissa and Kara, we got them moved back to once a month check-ins instead of once a week. So,
Gave you the wrong one.
Is the guy that was in jail.
Yeah, I'm alright. I'll
So,
be there shortly.
today, I still haven't discharged him because I need to cap around to go off. Prosecutor wants to send him to the grand jury, and they didn't do that today, but he asked for a week. So he's gonna come back on Friday and try to hire his own attorney within the week. Which I doubt is gonna happen, but. Probably not. Yeah.
Reach the place.
It's never over.
Recessed for workers around, showing that we have the showing up. So, I guess I'm gonna head over there.
Well,
And did you find anything about?
actually, let's get
His office received it on and I took it down. I don't know.
And we're Davis. Yes. Let's see if they're running. Are we running Betty Davis? Because I don't want to sit through a trial and
So we gotta figure out when he's gonna report back to you, so that you can report back to me.
I'm going to just go and get that assessment, get the assessment to you, we'll get that to you, and then about once a month, we spend some
So let's say, like October 2nd.
Yeah, give them a couple weeks to get the first initial things in there.
I have to put it on my calendar.
Okay.
I can't forget it.
Stupid.
That's what Brian said.
That's why I said it, because Brian said it too. Brian knows better than I do.
Oh, that goes in Stevie Ward's file.
You took it.
Huh? No, you said you found it.
Oh, I thought you took it.
We're all crazy.
Trump wants to execute.
I worked on
Chairman Bush's staff.
this trial
I saw that.
with Sean
Yeah.
last night,
No, not
because I thought, oh, this is gonna be
He's still-
easy.
Yeah.
It's a refusal,
I don't know if
it's
he's
a, you know,
still-
it looked like it was easy. Well, the video was 2.5 hours long, because it involved a canine search of the vehicle,
Oh,
and
Lord.
4 people in the car that each got separately interrogated.
Oh, what a
Out.
mess.
Execute
I'll
everybody.
go look at those other files and see what those are, if they got those.
Yeah.
Oh, there's Connor. Here? Yeah, he's here, hold on. Look like him. No, it wasn't him. It looked like him.
That's a shame.
Looked exactly like him. You know, like a young, baby face, yeah.
I call him?
Yeah, I will. I'll send it. I have a phone number, an old phone number.
Is this a good time?
Sure.
Okay. Ian is working on that for me. So I just spoke with him. This came
Okay.
for her.
That's all right.
Okay, so, and also this. Just an entry motion for the driving privileges. So just a minute, I need these signed. Please, these are on some discoveries that I've completed today.
Everything else going okay?
Yeah.
We didn't have many arraignments today.
I know.
Well, it was a not full, it was an empty.
It was really weird. I was like, something's going, the bottom's going to fall out somewhere, but it didn't. So, what do you need from me?
On this guy, he's decided that he wants to go to the grand jury instead of staying on treatment, so we're meeting a preliminary.
Okay.
On the second, Trooper Martin is our officer.
Okay, so it's a funny hand. Got it.
And I think, let's see here.
He's okay for the second, so he knows we just did paperwork. Gotcha. Okay. I'll get that taken care of. This I'm just gonna add to, or existing, what you have somewhere. I'm just gonna move this up. Put that in there. I'll take these with me as I go. Here, everything's good with this one and the, okay. Okay, Ken, you're welcome.
Awesome.
Right.
2 great games.
Right, yeah. Derek, he had his bets going. So dinner's on you, because he won.
Great.
Yeah.
Well, they were exciting games this weekend.
Yeah, I can't believe it, 0-0 until halftime.
Yeah.
I thought, what is going to happen? So I was glad for the outcome. We went to our friend's house and they were from Notre Dame. And I come decked out in my Ohio State.
I wouldn't even go to a party like that.
Right? Did you get some rest?
Worn out.
It's hard to rest when you're tired.
That Kyle Davidson
You were needing to get a,
case, I worked like 4
pretty
hours
much
on that.
somebody.
The video was so long.
Yeah, it was huge.
I found out that I can download those.
On Exxon?
Yeah.
Yeah.
And I tried to, but I didn't have a jump drive that was big enough.
I'm just
apparently.
asking.
Hypothetically, what was that?
16, but when you go to format it, Rob showed me a trick. When you go to format, there's a drop down where it'll say like exFAT, and you hit that and it allows it to go bigger. I don't know, so I just do that on all of them now.
Okay.
As soon as I put it in, I go to format, and then I do that little drop down, and it says exFAT, and I do that, and I hit OK, and it'll say format complete. I said OK, and then I check to make sure it has nothing on it, and then I just drag it all down.
Okay.
So if you want to do that exFAT at home, and do you have jump drives at home?
No.
Okay, well, I'll get you a couple to send, because I have 6 or 8 of them that Trish sent me, so I'll put those in a little baggie for you.
Okay.
You can take
Yeah,
those.
that's great.
I don't think you can do it on the basis of drug addiction that I'm aware of, but you can do it on the basis of like mental health capacity, but you're gonna have to get a doctor to say whatever they're saying. I don't know what they're supposed to say. I've never pursued that.
That's what that's all I always
Lay this down.
on guardianship or something like that. You have
This
to
is
have
on.
statement of expert evaluation.
Yeah, I think you did.
And the problem is what happens if you can't get something in place to get such a thing.
Right, that's the problem. Like in West Virginia. But then from there, hopefully get up to, get up. After they're stuck in the
That's on, that's on Stinson. As soon as I get that permit one, I'll release another one. This is on Stinson. Then I updated the discovery. I've
In a bigger place, there's somebody doing it, but around here, I don't think.
I'll let him know.
There's anything that
Trish, so Trish could forward it on to me, so I know if she was busy, so I just, everything I have for him, I just forward it to Trish. Do you need this file?
He didn't actually, might have some.
It's all been completed except for Barnett's.
Because he's done. So you might ask
Put
him.
it back in there?
You can give it to me whenever.
Prior, okay.
Want to ask him? All right, Kim Philby? We got,
So if you
everybody
have,
here's got a question for you.
if you got a relative that's got a major drug issue and psychiatric issues, but you can't get, I guess what would we call it, a statement of expert evaluation. If you can't get her to the doctor, or she refuses to go to the doctor, you have a doctor evaluate her. How do you go about
Get a guardianship.
getting guardianship?
You can file the petition with a motion for the court to order it. But then the question is, well, I'll tell you what, I think there's new legislation coming that allows for an order for law enforcement to make sure it happens. And I don't know if it's in effect yet or not.
You're the only person I know who even does this sort of thing. I know you don't do it often, but I don't know if anyone else does it at all.
And I know that that's a problem potentially, but I've never had it actually present itself in such a way that I had to get it resolved. Because usually what happens is that, well, they just generally don't have the problem. But usually the people that I deal with have kind of are already overseeing that person and don't have the problem getting the statement of expert evaluation. What is this in Scioto County?
Yeah.
Why don't you just go ask the judge?
Well, that's my next step. It's just something sort of come up with a client that it's her sister and she was messaging me. And I know the family and it's one of those situations where you just...
You wish you knew the answer quicker.
Yeah. Yeah, I tried to contact Mr. Davidson, but he didn't answer. How was your football game this weekend?
Her game was great. And of course, the Buckeye game was great.
Yeah, it was.
But I enjoyed going to the Herd game. I like it when there's a big, enthusiastic crowd there. I hate to go when the stadium's half full and it's like they leave at halftime to go drink in the parking lot. It's like, why even go? I mean, except people want an excuse to drink.
Was it full?
It was almost completely full, which is, almost completely full was great for Marshall. Students stayed for the second half. Usually they go because they got a keg waiting for them at the wherever. But not, they stayed. It was a good game.
About ready to go back here.
Okay.
All right.
Kyle Davidson is not here, so
Yeah.
get that one called.
Well, we've got a couple of recalls to do, and then we'll call Davidson, and then we'll
Okay.
do the suppression.
Something smells good.
Oh, they're making grilled cheese back there.
Oh, making roach.
Yeah. Vivian made grilled cheese, and it smelled amazing. I love grilled cheese.
I love grilled cheese too.
I haven't had a grilled cheese in a while, but that's what makes me want one.
You can get a grilled cheese at Sonic. It's right there.
Yeah, I
On
just
your
don't
way
go
to
to
town. Huh?
I never go to Sonic.
Really?
Yeah, I just...
I like Sonic.
You can
Cherry
go
limeade.
you can get a grilled cheese at Tudor's.
Yeah, I've never tried grilled cheese at Tudor's. How are they?
Good.
Give that a try. So they one at Ironton, right?
Yeah.
Because Tudor's is not consistent across different locations. Like, I like to get the politician biscuit in Huntington, but it's awful in Ironton.
Really?
Yeah, but I've had other stuff in Ironton I really like. But they can't make a politician biscuit, which is a bologna biscuit. Yeah. It's called the politician. It's like fried bologna, egg, and cheese.
Orange County Municipal Court's now back in session. With all the captures provided. State of Ohio recalls Edward Davis. Edward Davis, case number CRB 23570, A and B.
It's Mr. Steyer's case. You want to talk, I think, and...
Well, we had, the state wanted to contact the victim, so.
And we did that.
Done that.
And we consulted with them about the idea that we want to make sure that Mr. Davis does the counseling that we are agreeing to have him do in lieu of having a trial. But we're going to need to, so we would nolly the charge, but we're going to leave it to Mr. Steyer to give us updates for Mr. Davis to tell Mr. Steyer and get written reports that he's doing the counseling. And we will pick dates in which we are going to achieve these things. And if we get successful completion, then we won't refile the case.
And he's going to go to PATH, so.
All right, so at this point, as far as the court's concerned, it's going to be nollied, which Mr. Davis, for you, what that means is it's being dismissed, but not
Yes.
with what's called prejudice. If I dismissed it with prejudice, means it can't be refiled, but this can be refiled. If they don't think you hold up your end of the bargain, then they can refile it down the road, so.
What about the restraining orders and stuff, is that?
Well, it's all, those are all
The
gone.
protective order is gone, but they might go and get their own protective order from the civil court. But that's whether they do that or not is up to them.
Well, and that would be another condition on this too, that there be no further problems. It's
Right.
best if you just stay away from them.
Yeah, I've explained it's better to go ahead and minimize contact, but
So what we would expect, and we realize this isn't a function of the court at this point, but that Mr. Steyer would have us something by October 2nd to say that he's been assessed.
well, that's a week from now. So I'm going to say, I'll at least have them saying he's gone in to be assessed. I don't know if they'll just let him walk in and assess him, or if they're going to say, okay, great, glad you came, come back, such and such a date. But something showing that he's taken the steps.
Okay.
I think the best thing is right down the street here.
Right, I mean, I just don't know if they take walk-ins.
I would stop there.
Yeah, I don't know if they take walk-ins. I mean, if he walks in and they say, we'll come back on the 5th,
Yeah,
that still gives us something to show Mr. Heald.
Right. Okay, at this point, as far as the court's concerned, it's solid.
Thank you.
Luke, I'm putting it on my schedule.
Okay, I'll let you know next week.
State of Ohio versus Kyle Davidson, case number TRC 23764.
This is Mr. Stratton's case, it
Your Honor,
was
he
set
is not
today for trial. Mr. Davidson, it's 12:20 now, he hasn't appeared.
Your Honor, I attempted to contact him, I got no response, so I'm not sure where he is at.
Okay, so I will
Yeah.
issue a warrant for failure to appear, so it would say one.
Yes, Your Honor.
All right, be a warrant issued for Mr. Davidson, and he just has no R bond, he doesn't have any kind of surety bond up.
No. Thank you, Your Honor.
You're welcome.
State of Ohio recalls Betty Ross, case number CRB 16530. Your Honor, she's still not here.
I'll see you soon, I'm sure.
This is one that she has a bond up with Mr. Sowers, and he thought he could get her here. She still failed to appear, so I'll issue a bench warrant to him, and with a bond forfeiture hearing for October 16th. And I'll note that Josh, Mr. Sowers, that she did fail to appear today.
Give me those. I think we're about ready to get started.
State of Ohio versus Joyce G. Ferguson, case number TRC 2345A and B.
And this is on a motion to suppress filed by the defendant set for evidentiary hearing today. Both sides ready to proceed?
Yes, Your Honor. Yes, Your Honor.
Right, Mr. Heald?
Your Honor, we call Sergeant McFan.
Sergeant, if you'll come up to the witness stand, raise your right hand, be sworn in. Do you swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? You may be seated.
Sergeant, could you state your name and where you are employed?
Sergeant Mark McFan, the Ohio State Highway Patrol.
You with the Ironton Post?
I am.
How long have you been with the Ohio Highway Patrol?
23 years.
And how long have you been a sergeant?
4.5.
So you were on duty on January the 14th, 2023 at about 1:07 a.m.?
Yes.
And at that time, did you come into contact with Joyce Ferguson?
I did.
And where were you when that happened?
I was westbound on US 52, mile post 17, 16.
And that's here in Perry Township, Lawrence County, Ohio?
Yes.
Right in the area of South Point?
Yes.
Do you recognize Joyce Ferguson in the courtroom today? And if so, can you point her out, please?
Yes, it is. She's sitting right there.
Record will show you pointed to the defendant.
Now, when you first noticed Joyce Ferguson, was she driving a vehicle?
Yes, she was.
And what was happening when you first saw her? What first drew your attention to her?
She was, as I come up on her, she was swerving in her lane, and as I continued to follow her, I observed multiple parking lane violations.
So, as a result of those observations, what did you do next?
I initiated a traffic stop.
Those traffic violations, did that give you some reasonable suspicion that there might be an impaired driver?
It's possible.
Now, when you were on duty and patrolling that morning, did you have working video cameras in your car?
I did.
And were you wearing a body cam?
I was.
And after this case, after you made the arrest, did you upload the video to the Axon system?
I did.
And since then,
If to save some time, I'll stipulate to the videos and their authenticity.
thank you.
Save Mr. Hill some air. I know he's not, I knew you wasn't feeling good, so.
Thank you. You've reviewed the video since this happened?
I have.
Do you recognize this video?
Yes.
Is this you following Ms. Ferguson?
Yes.
Does this look like a fair and accurate representation of what you were seeing that night?
Yes.
Maybe your eyesight's a little better than the video camera, though?
Yes.
I'll object to that, Your Honor. I don't know that it really matters for purposes of hearing, but that would require an expert opinion.
Oh. Is that her going over the line there by substantial?
It is.
That you might point out when you see her?
Yeah, she went over the line again. She was over the center line. And she's back on the white line there.
So you activated your lights to stop her?
I did.
She stopped right then?
Yes, you should for it.
After that, you got pulled over. Did you then approach the vehicle?
I did.
And confirm that it was Joyce Ferguson actually operating the vehicle?
Yes.
So when you first encountered her, what did you notice?
I first walked up to her, when she looked at me, I immediately noticed her eyes were glassy, and she had crumbs of food on her shirt.
Did you ask her for her license and various documents?
I initially asked her for a driver's license, registration, and insurance card.
And did she give you those things initially?
She handed me her driver's license.
Did she hand you something that you didn't ask for?
We had a short few words, and I asked her again for her registration and insurance card, and she handed me an old ticket that she had received.
So that isn't what you were asking for. Did you talk to her about the fact that you saw her weaving?
Yes.
Did she?
Oh, I'm sorry. She said she was eating a taco.
Did she start to give you any information about health issues she might have?
She said she had a brain aneurysm and a thyroid condition.
Did she volunteer those things?
Yes.
Did she tell you where she was coming from and what she'd been doing?
She told me she was coming from work and she worked at the courthouse.
And what time of day was this?
1 o'clock in the morning, 1:07 in the morning.
Did that raise any suspicion with you as far as the explanation?
Yeah, I was curious, yeah.
Did you notice anything about her body movements that you felt were indicative perhaps of impairment?
Just that she was retrieving the items I was asking for when she was looking through her paperwork. Everything just seemed slow.
Did you smell an odor of an alcoholic beverage?
While I was talking to her, I did catch a faint smell of an alcoholic beverage. Yes.
Did you ask her if she had anything?
I did ask her, yes.
And what did she say?
She said no.
Before you, while she was still seated in the car, did you do any preliminary type tests that might help you decide if she might be impaired?
I did. I did a quick misdiagnosis test, HCN test. I didn't want to get out of the car. I did get a quick HCN just to give me an idea before I took her out.
What did you observe then?
I noticed immediately the lack of smooth pursuit.
And at that point, you asked her to get out of the car?
I did.
Okay, so you were seeking reasonable suspicion that she may be impaired?
Yes.
And looking for clues?
Yes.
So if you could kind of summarize all the clues that you gathered to determine that you should get her out of the car?
The driving, poor driving, the glassy eyes, the crumbs on her shirt, just the slow movements, and the faint odor of the alcoholic beverage, stomach inside the SUV.
Did the statement about where she had been, that it was 1 o'clock in the morning, did that have anything to do with it?
Yes, and that was unusual also.
I'm going to play some more of this video.
I think it's right around the 3-minute mark, maybe not on that one. Okay.
That's medical issues, right? Brain aneurysm and thyroid. Ashland. Yeah.
I heard the registration. Yeah, I didn't hear. This is the old thing. Where are you coming from?
And I was working over at the courthouse.
Okay.
See, that's it. There's glasses on.
All right. Any great thought?
No.
All right, if you don't care, I'm just gonna take her out real quick. All right, you don't want to contact me?
No. I'm not set up.
I see my finger.
Yeah.
So at that time, you got her out of the vehicle? Is that right?
I did, yes.
When you got her, when she came out of the vehicle, did you notice any physical things about her which would indicate perhaps that she was impaired?
She stayed, unsteady on her feet when she was walking back to my patrol car.
At that time, were you able to smell the smell of alcohol?
Once I got her in front of my patrol car and I was standing face to face with her, I could smell the alcoholic beverage, yes.
Did you ask her again if she had anything to drink?
I did.
And what did she say this time?
I believe she said she had two.
Did she put a time frame on it and say when she had it?
Around 7 o'clock that evening, maybe? That's what she said.
Did you ask her what time it is now?
I did.
And what did she say?
She said she didn't know what time it was.
I smell, that's why. Okay, all right, so you say you got that?
2 years.
Hold on,
In the defendant's motion, it's alleged that the video does not show that defendant's eyes were bloodshot or glassy. Did you ever state anything about bloodshot eyes?
No.
Did you see that her eyes were glassy?
I did see that her glassy, they appeared glassy, yes.
Were your eyes closer to her eyes than your camera was?
Yes.
Were you able to see it better than your camera could see?
I'm going to object again for the record, Your Honor.
Yeah.
That requires an expert opinion, and there's not been any evidence of camera resolution provided by the state of Ohio if they're going to attempt to get into that, so that either myself or the court could ascertain whether that is possible or that's just conjecture.
At this stage, were you beginning to start the process of standardized field sobriety tests?
I was, yes.
Now, as a sergeant with the Ohio Highway Patrol, are you required to be certified by taking a class instruction that is put forth by the National Highway Transportation Safety Administration?
Yes.
Do you have to be certified in that course?
Yes.
Did you pass that test?
Yes.
You wouldn't be able to work on the road at all if you weren't certified in that.
Correct.
Previous to this hearing, I showed you this manual, You recognize what this is?
Yes.
Your Honor, I'm going to put a couple of objections on the record at this time. Your Honor, I believe that is the 2019 or 2018 manual. The statute requires the troopers to be up to date on the most current manual based upon their training. I specifically asked in discovery which particular manual the officer was trained upon. I was not given that information. I was given a general link to all manuals that are possible through NHTSA rather than the specific individual manual this officer was trained upon.
Mr. Gill?
Well, first of all, as a practical matter, if there is any kind of difference in the way that a test is administered, I haven't found in these tests from 2015 to 2018. This is the latest one.
No.
And he is currently certified.
Your Honor, the latest manual is the 2023 NHTSA manual, of which I am a certified field sobriety practitioner after taking the same class that the officers had.
Well, I don't know. This was back in
January 14th.
January, so
Okay.
early 2023.
I'll let you produce the evidence, and then we'll see if there's evidence that the standards have changed, or that he's not up to date on current standards.
Thank you, Your Honor. So, Sergeant, did you review this manual before we had the hearing today? And did you see it to be exactly as you remember it being as far as what should be in this manual? In other words, it's authentic. It's authentic. And I made copies of the relevant parts of this, and you looked at those too?
Yes.
And they match what's in this book? Yes. So, did you administer the horizontal gaze on status test?
I did.
And you're trained in that?
Yes.
And I would like for you to tell me what horizontal gaze nystagmus is.
Horizontal gaze nystagmus is the involuntary jerking of the eyes, brought on by the onset of, or brought on through the, caused by the alcohol effect.
If an alcoholic beverage is consumed?
Yes.
So explain what the test is like.
So when we get the test, we ask them to move the glasses if they're wearing contacts. And then we ask them to have any head injuries, which she had already provided. That was part of her medical condition. And then I have them follow a stimulus, 12 to 15 inches in front of her eyes. And I check for her pupil size, resting nystagmus, and pupil tract. And then through the test, we look for lack of smooth pursuit, nystagmus at maximum deviation, and onset prior to 45 degrees.
And Your Honor, as far as the HDN test goes, I will stipulate to the officer performing it adequately, as well as the results of the HDN test.
Okay.
I'm going to show you, we have marked here as State's Exhibit 1. And I ask for you to know what this is.
That's our impaired driving report that we fill out after we complete an arrest.
And is this the one from this case, which was the first?
Yes, it is.
And what were the results that you observed on the horizontal gaze nystagmus?
The only thing I marked is lack of smooth pursuit.
Was that the same thing that you saw when you did the short test while she was still in the vehicle?
Yes, it was.
I'm going to ask that this be admitted, Your Honor.
No objection.
Be admitted. Probably need to get your conclusion of that test, did you then proceed on to enact another test?
Yes, I attempted to have her perform the walk return.
Were you able to do that test?
She was not able to stand in the instruction. During the instruction phase, she couldn't stand up to it. So I did not do that test.
Prior to doing the test, do you, as a rule, ask the participant if they have any physical limitations that might impair their ability to do the tests?
Yes.
And did you ask her in this case?
I asked her.
Did she explain to you about brain aneurysm and having had doctoral surgery?
Yes.
Did you at least begin the process of doing the test?
I tried to place her in the instructional position, and she just was not able to stand like that.
Did you, at that time, have some feeling about whether this was because of impairment or because of some other physical limitation?
I believe at that point it was impairment.
I'm going to object to that, Your Honor. I don't believe that could be testified to at this hearing, given whether it's a medical ailment or whether it was impairment. And I intend to bring out some of that on cross-examination with the HGN test that was just stipulated to.
And I'll reserve on the ruling.
Thank you, Your Honor.
Yeah, I somebody else.
We're to the public testimony. You will trial. We think you can build.
I'll try.
You can drive.
I done 7 surgeries last time.
Oh, that is.
Yes, sir.
You say you had an angry or
Aneurysm?
Yeah.
I've got a stent in the wolf, and I've had 3 surgeries of thyroid. Stubborn, and focus, and check up.
Okay, if you want to be training inside these, it's up to you. If you want to, you think you can do it? I just want to ask you if you want to try and
I've got migraines and I just sort of like when I was eating the taco.
Yeah, I understand. Yeah. But if you want to try these, just stand here with your the left foot. We'll have the back knee line right here, okay? Bring that back just a little bit. That's it. Okay, we'll have the back knee line. Put your left foot, put your right foot in front of your left, heel touch and toe. Heel touch and toe just like this, okay? Hands down your side. Can you stand heel toe? Like this, you stand heel toe?
Yeah.
Just like this. See how my feet are?
Right here?
Right foot in front of your left.
Right?
Just like this.
Like that?
Good, like that. But heel touch and toe.
Okay.
Just like there you go. Now hands down your side. Oh, we'll do that. Okay. Let's try left. Let's try.
After concluding that one, did you move on to another standardized field sobriety test?
Yes, the one night stand.
I would like for you to, well, first of all, as part of your training through the Highway Patrol as to the NHTSA standards, did you also have training on how to correctly administer the one-leg stand test?
Yes.
And you had a chance to review the pages of the 2018 manual that you looked at before, and these copies that I made, and they're the same thing?
Yes.
And I would like for you to explain what the one-leg stand test is, how you do it, and why you do it. You know, what are you looking for?
The one-leg stand test, it's a divided attention test. You're looking to see if for the ability for them to follow instructions and be able to perform the test. So on the one-leg stand, I place her in the instructional position with her feet together, hands down at her side, while I explain the test to her. And part of that is to perform that act while listening to my instructions of the test, and then performing the test at that.
Is that what they refer to as divided attention?
Yes.
So tell the court what you asked her to do.
So I asked her to stand with her feet together, hands down her side, and stay and remain in that position while I explain the test to them. And not to start the test until told to do so. Once then I'll demonstrate the test by, I'll tell them to lift one foot, whichever one they're comfortable with. Doesn't matter which foot. We'll pick one foot, approximately 6 inches off the ground. They'll point their toe, they'll look at their toe, and they'll count out loud 1,001, 1,002, their hands to their side. And I tell them to count until I stop them. It's a 30-second test, so I'll time them while they're doing the test. And then once the 30 seconds is up, I'll stop.
Your Honor, I'll need that example. So, did she actually perform this test?
She did.
And I'm going to show you what's already been admitted as State's Exhibit 1. Do you have the results of your observations of her on that test?
Yes.
And what did you see?
She was swaying while balancing, and she put her foot down on 2 occasions during the count.
In the motion that they filed, they state that she performed the one-leg stand test well. Would you agree that she performed it well?
I don't think it's a matter of if she performed it well or not. It's just we're looking for certain clues, just things that we identify as a possible clue.
Just stay feet together, hands down your side. Okay. Let's say it's begin. We're going to take one foot off the ground, approximately 6 inches. Okay, approximately 6 inches. You're going to point to the other, we'll count out loud, 1,001, 1,002. Keep your hands down your side, okay? All right, so when I say begin, it's going to look something like this. All right, so when I say begin, pick your foot up, start this. About 1, about 2, about 3, go to 200. You can park 6 inches off the ground, you will count out loud, okay? It's a 30-second test, you have to stay like this, and I'll take you to the start. If anytime during the test, put your foot down, stay back up, until you count where you left off, okay? You understand? You take your foot out of the place. Okay, whatever you place.
And again, what were the clues that you observed there?
Swayed while she was balancing, and she put her foot down on 2 occasions during the count.
Having reviewed these pages from the Misdemeanor copy from the manual, marked as State's Exhibit 2, did you administer that test with substantial compliance to the NHTSA guidelines.
Yes.
And this is an accurate copy of those pages,
Yes.
right? You look at it. This is-
I haven't seen it, Your Honor. I presume there's no objection. If Mr. Hilt says it's
It's
the manual,
acceptable, I mean.
then I'm happy with that.
Okay. Move subject to further cross-examination.
What was the next thing that you
The next thing I had to do is run to a preliminary breath. Yes.
Your Honor, I'm going to object at this time. I always ask for all sorts of information about the preliminary breath test and discovery in multiple areas in my discovery demand. I've never received anything. This court's ruling has always been that if it's not provided in discovery, it does not come in, and I would ask that the court continue that ruling as it has in other cases.
We don't intend to present evidence of the score, just that it took place. It happened.
Okay.
And I think that's sufficient, that he can say they did a test, but without the score, because I don't believe without the discovery.
And that's
that could be-
fine. If I could, I'll just skip ahead and we can stipulate that there was a test score.
Well, I won't stipulate to a score.
I'm sorry, that there was such a
That there was a test, but not the
Yes.
score, because
Right.
that, I don't believe, could count towards probable cause.
Okay, after that process, the preliminary breath test, what did you do next?
Placed her under arrest for OBI.
All that video that we looked at and that we watched here, did that all accurately reflect what you observed and what you took part in that evening?
Yes.
The parts of the motion refer to Trooper Malone. Was he there that night?
He was not on the stop. No, he might have been.
That would be a typo.
That's all I have, Your Honor.
Any cross-examination?
Thank you, Your Honor. Sergeant McFan, you were trained, let's kind of back up. What NHTSA manual were you trained upon?
I believe it was 2001.
Okay, so you were originally trained on the one, and I believe the patrol requires updates or refreshers as new manuals come out.
That's part of our training, yeah. Part of our roll call training.
Okay, so you've had, I believe, a 2005 refresher, then
2008, I think it was one.
there was one in 8, I believe there was
13 maybe.
15, 18. Okay, so you've had several refreshers, but you haven't had the 2023 refresher at this point?
No.
Okay. As part of your training, you were trained to write full, accurate, and thorough reports, right?
Yes.
And that is actually in the NHTSA manual,
Yes.
and that's what you did in this case, right?
I believe so, yes.
Okay. That would include anything that you believe to be an indicator and your observations, right?
Yes.
That would also include things that Ms. Ferguson did correctly then as well, right?
As far as in my report, what should be correctly, I'm not sure about that.
Okay. Well, you testified you wrote a thorough report, and thorough report would include things that the defendant didn't do well and things that the defendant did do well, right?
Correct.
Okay.
I'm going to object to the question. I mean, that can be an infinite number of things. I mean, and how does somebody determine what they're doing correctly? I mean, just they're breathing, that's correct, she's alive. I just don't know how the trooper can be responsible for writing every possible fact.
I mean, I'm talking facts from the investigation, not necessarily that she was living.
It is a confusing question, but, I mean, I'll let him answer it if he can.
I don't know how to answer that question, really. I mean, if she's not doing anything, like, if it's not wrong.
Well, so let me give you an example. At some point, and this is going to be jumping ahead a little bit, you had asked Ms. Ferguson out of her vehicle, right?
Yes.
And she didn't fall down, right?
No.
She didn't have to lean on the car for balance, did she?
No.
She didn't stumble.
She did not stumble, no.
Okay, so those are things that she would have done correctly that you didn't, and those would be part of your report then.
If she didn't stumble or didn't lean on the car, that's not an indicator that, why does that have to be in there? Obviously she did it correctly.
Okay, so
I didn't, you know.
So you're only interested.
If I'm asking her out of the car, she's going to exit the car, and if I have her walk back to my patrol car.
Sure. Now, if she'd have done any of those things that I just asked you, you would have put that in your report though, wouldn't you?
Yes.
So you're only interested in evidence that supports a conviction.
But if I didn't say she fell, we know she didn't fall. I guess I don't understand either.
Okay, fair enough. Let's go back to your training through NHTSA, and you were trained that there's 30 possible vehicle in motion clues, right?
Yes.
Okay. And do you recall how many, I guess, subcategories of those that NHTSA indicates? Does 4 sound correct to you?
It might be.
So if I told you that it was problems maintaining proper lane position, speed braking problems, vigilance problems, and judgment problems, does that?
Sounds correct.
Okay, so that rings a bell. All right, so let's kind of go through some of these. You didn't witness any turning with a wide radius. You didn't witness her almost strike an object or a vehicle. I believe you put in your report there was swerving, right?
Yes.
And we're going to pull the video up again in a second. A swerve denotes a very quick jerk, right?
It could, I guess. But also, it could, yes.
Okay, so, but there would be a difference between weaving
Yes.
and swerving. And you just watched the video.
Yes.
It appears Ms. Ferguson is more weaving than swerving. Would you agree with that?
Yes.
Okay. And I know she came up, or when you walked up, she said, I was swerving, but she hasn't had the same training that you and I have had. So you would agree with me that she was weaving and that she weaved across the lane line?
Yes.
Okay. So, of those clues, potential cues and indicators that there was weaving and weaving across the lane line. That's what you saw, right?
Yes.
For maintaining proper lane position. She didn't have any problems stopping her vehicle,
No.
did she? She didn't accelerate or decelerate rapidly.
No.
She didn't have varying speeds going forward, moving back. And she wasn't doing lower than 10 miles an hour below the speed limit, right?
No.
Okay, so she didn't have any speed and braking problems that you observed. You didn't have any indication that she was driving in an opposing lane or anything like that?
No.
No slow response to any traffic signals?
Wes?
Excuse me.
No.
Okay. She wasn't slow or didn't fail to respond to your signal?
No.
In fact, she responded pretty appropriately and then pulled off correctly,
Yes.
right? She had her headlights on.
Yes.
She didn't stop in traffic or in the lane of travel. And she actually signaled and can signal consistently with her driving as she was pulling off.
Yes.
Okay. So of, the vigilance problems that you would have observed, Ms. Ferguson did all of those things, was performing the operation of the motor vehicle correctly in the way that you would expect a normal sober driver to do.
Yes.
Okay. As far as, the driving portion goes, you would agree with me that, drivers who are not impaired sometimes make marked lanes violations.
Yes.
And that wouldn't be a determinative factor in your analysis, right?
Right. Yes.
Okay. Yeah, but that would be one indicator.
Yes.
And that would be your reasonable suspicion for the stop.
Yes.
At that time, you couldn't tell whether Ms. Ferguson, at the time of driving, you couldn't tell whether Ms. Ferguson was impaired or she wasn't,
No.
right? She wasn't driving on anything other than the designated roadway, right?
Yes, sorry.
It's okay. You didn't observe any illegal or improper turns.
No.
She didn't make any improper or unsafe lane changes.
No.
There was no other inappropriate or unusual behavior other than at the time of driving that you're observing.
No.
And she wasn't following anybody too closely, right?
No.
So, as far as judgment problems, you witnessed her driving the motor vehicle the way that you would expect a normal sober driver to drive the vehicle.
With the exception of the wheel.
Well, that was problems.
Okay.
Maintaining proper lane. This is just judgment problems.
Yes.
Okay. So out of those 30 clues, you had two possible cues out of 30, right?
Yes.
Or excuse me, that would be 2 out of 24. She didn't make any efforts to flee, right?
Right.
There was no response to any emergency equipment. That really wasn't applicable here. She didn't have a slow response.
No.
There was no abrupt swerve.
No.
There was no sudden stop.
No.
She didn't strike any objects or curbs or anything like that.
No.
And at that point, after you turned on your lights, she didn't commit any new violations,
No.
right? So now you would agree with me then that that would be 2 indicators out of 30,
Yes.
right? And those are all indicators that are set forth in the NHTSA manual and through your training.
Yes.
So at this time, you walked up and you began what would be considered by NHTSA phase 2 of your investigation, right?
Yes.
And there are 3 phases. It's drive the vehicle in motion, personal contact, and then pre-arrest screening.
Yes.
Okay. So, would you agree with me then, and maybe save a little time here, the phase 2 personal contact cues that NHTSA has listed 28 of them?
I'm not sure.
Okay. Well, we'll go through them. As far as sight cues go, you've not indicated that you saw bloodshot eyes, right?
No.
You didn't indicate flushed face. You did indicate you smelled the faint odor of an alcoholic beverage,
Yes.
right?
Yes.
Okay. So as far as consumption goes, would you agree with me that bloodshot eyes is listed in the manual as an indicator?
Yes.
Glassy eyes is not listed, is it?
It is not.
Okay. So that is not listed by NHTSA as a possible indicator of impairment.
Right.
Flushed face,
That is yes.
listed as an indicator. You didn't indicate in your report that you witnessed flushed face, even though it was cold. You'd agree with me then that alcohol is a vasodilator.
It is yes.
Okay. So the indication of possible consumption that you had was the faint odor, which typically, would you agree with me that the odor, whether it's faint, whether it's strong, is typically an indication of when the beverage was consumed.
Yes.
Okay, so a strong odor was likely to be consumed in a recent time rather than faint odor would be a longer time typically.
I don't know, possible, yes.
Okay, fair enough. Ms. Ferguson didn't have any soiled clothing, right? When you had asked for documents, she didn't have fumbling fingers, she didn't drop anything. You didn't witness any alcohol containers.
No.
No drug or drug paraphernalia.
No.
No bruises, bumps, or scratches on her.
No.
She didn't really take any unusual actions, right? She didn't try to get out of the vehicle or
No.
unprompted. Now, you had indicated, I believe, and your testimony would be that she had forgot to produce some of her documents initially.
Initially, yes.
Okay. And then once you had asked for it, to be fair, you had indicated, and I think it showed on the video, that she had handed you an old citation. But she also had the registration in her hand at that point.
I believe that was the registration.
Okay. But you didn't look at it?
I could see it when she was holding it. I don't remember what it was, but it wasn't a registration.
Okay. And that's in your report?
It is not that.
Okay, so today's the first time we're hearing that?
Yes.
Okay. There's no indication that she was having problems seeing the documents, right?
No.
She didn't fumble or drop her purse or any of the other documents. I think you already said that.
Yes.
And it doesn't appear that she was unable to retrieve the documents with her fingertips. She wasn't, reaching down and kind of with her hands. Okay. So, out of the 12 potential site cues that you've got to look at, there were 2, right?
Yes.
You're familiar with the hearing cues that NHTSA has promulgated in the manual?
I know the hearing cues now.
Okay. As part of phase 2, personal contact, and you need me to show you in the manual. So, well, I probably save some time here. So you're not familiar with the cues for instance, slurred speech, responses, any of those things?
Yes.
Okay, so you are familiar with the English. Okay. You had indicated that she had slow speech, right?
I don't think I said slow speech. I think her movements in the car were just slow. I don't think I said slow speech.
I see the impaired driver report here.
I know I indicated in the narrative, I don't remember.
Under speech on the impaired.
Okay.
Does that slow?
It does say slow, yes.
Slow speech is not an indicator in the manual, is it?
No.
Okay. In fact, the only indicator in the manual is slurred speech, right? We've seen most of the video that's been played at this time. Ms. Ferguson didn't have slurred speech, did she?
No.
In fact, she was speaking normally.
Yes.
At the initial time, during phase 2, prior to pulling her out, she'd indicated that at that time she had been drinking, right?
Yes.
Okay. So at that point, there was no admission of drinking.
Right.
She wasn't giving you inconsistent responses.
No.
She wasn't making any unusual statements.
No. What? Yes.
Okay. What's the unusual statement?
She's come from work at the courthouse.
Okay. Have you ever gone to work in this job or a previous job and then done anything else afterwards?
Yes.
Sure.
But that's not what she said.
She said she was coming from work. If she went to work that day, she could have also been coming from work, right?
Yes.
She didn't have to tell you, if she went some other place, does she?
No. She
Okay. And she wasn't using any abusive language towards you?
No.
And as someone that would be considered impaired typically is angry and uses, sometimes uses abusive language?
Sometimes, yes.
Right. Okay. So out of the hearing cues, there was, depending on if you want to take that as an unusual statement, say 1 out of 5 then, right? Is that fair?
Yes.
Now you said, as far as smell clues, you had indicated that you smelled a slight odor of an alcoholic beverage, right?
Yes.
So it wasn't strong, nor moderate, it was faint. I think faint was actually the word that you used. You didn't smell any cover-up odors.
No.
Didn't smell marijuana or any other unusual odors. So there was one cue of 4 as far as the smell goes.
Yes.
Okay. Now, you had her exit the vehicle at that point.
Yes.
Now, as part of your training, if you smell the odor of an alcoholic beverage from the vehicle, you're taught to remove the driver from the vehicle to attempt to ascertain whether it's something in the vehicle or from their person.
Yes.
Right? And I would indicate to you that you're not even, there's, under Ohio case law, there's not any stipulation that would say that you can remove would you agree with me, you could remove the driver for any reason?
Yes.
From the vehicle?
Yes.
Now, typically, officers don't do that, right? But under the law, you can.
Yes.
So at this point, you're attempting to develop reasonable suspicion to move to phase 3 of your investigation, pre-arrest screening.
Yes.
All right. So you then had her exit the vehicle, and that's part of phase 2, personal contact, right? Because at this point, you don't know where it's coming from. Did she have any angry or unusual reactions to getting out of the vehicle? She followed your directions to get out of the vehicle, right?
Yes.
She opened her door.
Yeah.
She didn't leave her car in gear.
No.
She didn't have to climb out of the vehicle.
No, she did not.
All right, she didn't, I think you already testified she didn't lean against her car, and she didn't need to use her hands on the car for balance. So those cues, as far as the physical nature of getting out and walking and doing those things, she did those appropriately like you'd expect someone to do.
Yes.
Okay. Once you got her out of the vehicle, did you ask her give her any divided attention tasks to do, such as asking her other questions or indicators?
No, I didn't.
Okay. Now, as part of that's a training, that's something you're trained to do if you believe someone is impaired,
Yes, you can.
is use questioning to divide their attention.
Yes.
Okay. And you didn't do that at that time,
No.
right? You're also taught as part of your training to ask questions about medical conditions, right?
Yes.
During phase 2.
Yes.
Questions about disabilities.
Yes.
You didn't ask any of those, right?
Well, she had volunteered some medical insurance. Contact.
Sure. You didn't ask her any follow-up questions about that during phase 2. You didn't ask her if she's presently sick or injured. You didn't ask her if she's under the care of a doctor or dentist. You didn't ask her if she's diabetic.
I did not.
Didn't ask her if she was epileptic.
No.
You didn't ask her if she's taking any medications.
No.
And those are all things that you could have asked her.
Yes.
Those are all things that NHTSA indicate, or all the conditions NHTSA indicates can potentially mimic impairment.
Yes.
And additionally, they're also divided attention tasks as well, because you're asking questions seeking appropriate responses.
Right.
So you would agree with me that you could have done that at this time,
I could have.
but you didn't?
I didn't.
Okay. Additionally, NHTSA prescribes some few other techniques for divided attention tasks that are training. That'd be the alphabet test, the countdown test, and the finger count technique.
Yes.
You didn't, during phase 2, administer any of those tests as well?
I did not.
Okay. Okay. Now, at this time, you had her out of the vehicle.
Yes.
You would, in speaking with her at this point, she had said, well, she had had 2 beers earlier.
Yes.
Is that fair to say?
Yes.
And you indicated you could still smell the faint odor, but this time coming from a person.
Yes.
Okay. So at this point, you began to conduct phase 3 pre-arrest screening, right?
Yes.
First test you conducted was the horizontal gaze nystagmus test.
Yes.
You had indicated, I'm not even going to that. You had indicated on the test that you received 2 cues.
Yes.
Or 2 clues.
Yes.
Valid, because in this test, they're actually considered by NHTSA anyway to be validated scientific clues.
Yes.
How many clues are possible?
6.
Okay, that's 3 each eye,
Yes.
right? And you only received the first 2 clues.
Yes.
According to the San Diego study that's published in the manual, when conducted properly, the horizontal gaze nystagmus test is the most reliable indicator of impairment.
Yes.
And further, the manual specifically indicates that 4 cues is the number that the officer needs to reach to indicate impairment.
Yes.
In this case, you only saw 2.
Yes.
Right? So you had lack of smooth pursuit in the left eye and the right eye.
Yes.
But on distinct and sustained nystagmus at max deviation, you didn't receive a clue in either eye.
I did not.
And onset prior to 45 degrees, you didn't see a clue in either eye.
I did not.
Okay. Are you familiar with Tharp's equation?
I am not.
Okay, well, we won't go into that. That's more of a DRE situation. And the research indicates that if you have 4 or more clues, there's a 88% chance that the BAC is higher than 0.08,
Yes.
right? And in this case, you only had 2.
Yes.
All right. On the walk and turn test, you had attempted to put Ms. Ferguson in the instructional phase
Yes.
of it. You didn't complete the test, right? So you don't have any validated clues here because you didn't complete the test. But as you sit here today, you can't indicate, you couldn't render a professional opinion as to whether it was impairment that kept her from staying in the starting position or some form of medical condition.
My suspicion was it was impairment.
Sure, but you can't say for sure.
No, I cannot.
Okay. And again, you didn't ask the medical related questioning in phase 2 that might have allowed you to be able to determine some of that.
I did not.
Okay. The one-leg stand test. You had indicated that you gave the instructions and completed the test, which you believe in substantial compliance.
Yes.
And I believe that you had indicated while you were testifying that the standards that you're supposed to, or the instructions you're supposed to give is stand with your feet together, arms down at your side. You're supposed to demonstrate that stance. Do not start until instructed to do so, and ask for whether or not Ms. Ferguson understood the instructions to that point.
Yes.
Okay. Then it was when I tell you to begin, you raise your foot approximately 6 inches off the ground. You're supposed to demonstrate it for her at that point. Keep your raised foot parallel to the ground. I believe you said pointed.
Yes.
Kind of the same thing as far as that goes. Keep both legs straight.
I'm not sure if I said that.
Okay.
And I'm going to object to line of questioning on this because there wasn't any allegation that he instructed her incorrectly.
I'm getting there.
Well, I mean, you didn't make an allegation in your motion. You just said that she performed it well.
I believe in the motion, it specifically says, Introduction, number 7, introduction of any field sobriety test should not be admissible in a probable cause hearing. At trial, said tests are not, well, hang on, I've got it further down here, I believe. You're correct, it's not in there. Okay. You had indicated that nystagmus is caused by consumption of alcoholic beverages.
Is the involuntary jerking of the eyes.
Right. And is that due to the consumption of alcoholic beverages?
It can be, yes.
Okay. So if you testified earlier that it was due to alcoholic beverages, it could be, but it's not necessarily. There's different other types of nystagmus.
Yes.
Resting nystagmus, neural nystagmus, rotational nystagmus, and probably the more pertinent one here would be positional alcohol nystagmus.
Yes.
Right? Okay. So you're taught when you administer the HDN test that the subject's neck and shoulders are to be aligned, right?
Yes.
So you could give it sitting down as long as they're looking straight ahead and their shoulders are aligned, right?
Yes.
So you would agree with me that if you have someone, if they're looking up, that can cause positional alcohol nystagmus?
Possibly.
Okay. I mean, doesn't necessarily all the time, but that can be a cause of positional alcohol nystagmus, right?
Yes.
Okay. So if Ms. Ferguson was looking up in the HDN, that could potentially account for the lack of smooth pursuit that you indicated you observed.
Maybe.
Okay, so it could, right?
Possibly.
Okay. You had, I believe, the agreed upon testimony was you conducted a field sobriety test, and that would have been after the field sobriety tests were given, right?
I'm sorry, what?
Or excuse me, you conducted a portable breath test after the field sobriety tests
Yes.
were given, right?
Yes.
Okay. And at that time, based upon your observations, you had, on the field sobriety testing, there was 2 clues on the HDN test, right?
Yes.
Which you've acknowledged is the most reliable,
Yes.
most accurate. Matter of fact, if someone can't perform the other tests, where they have medical conditions, NHTSA indicates just perform the HDN test, right?
Yes.
Because it's the one.
Yes.
And based upon that, 2 clues is not indicative of impairment, right?
It is not.
Okay. I don't have anything further, Your Honor.
Mr. Hewitt. Sergeant, I don't know what soiled clothing means, but you already testified that there was something about her clothing that you noticed.
The crumpled too.
That's all I have, Your Honor.
Just one more question. Soiled, correct me if I'm wrong, typically applies to someone that has either urinated or defecated themselves.
Yes.
Okay. And that wasn't the case here, right? She'd indicated that, matter of fact, when you walked up, she said, sorry, I was eating a taco.
Yes.
and that would have been indicative of what you saw. Nothing further, Your Honor.
You may step down, thank
We rest, Your Honor.
you. Any evidence from the defendant?
No, Your Honor, just a closing after Mr. Heald would.
I'm sorry, I didn't understand the last thing.
Sorry, just a closing after Mr. Heald would give one.
We do need to admit the video.
No objection.
It's admitted, and your 2 paper exhibits are admitted. All right. Mr. Hill, do you have anything you want to say?
I believe, Your Honor, for please the court, that we have shown, first of all, I don't think there was any dispute about the reason for stopping the vehicle, the swerving. She admitted to immediately when the stop was made, and we saw it on the video. You know, I understand Mr. Cremines' idea about, well, she didn't fall down, well, she didn't vomit, well, she didn't. You could go through a myriad of things that she didn't do wrong, and that's not what this is about, and that's not a reality of when a person's impaired by alcohol. The trooper is, in this case the sergeant, is trained to look for the things that are indicators. And I think that we had a number of them to support every step of this, from the stop all the way to the arrest. So I think that there was probable cause all the way through. And so we'd ask for the motion to be denied.
Thank you, Your Honor. Your Honor, it was never contested in the motion as to the stop. Mr. Hill is correct. However, as part of the totality of circumstances behind that the court's to look to, you know, vehicle in motion is one of those. The testimony was initially swerving, but then it was more weaving, which I believe matches up with what's on the video. There were no speed and braking problems, there were no vigilance problems, there were no judgment problems, and there were no after the command to stop problems. Upon approach, Your Honor, to phase 2 personal contact, you know, it was indicated there were glassy eyes. Well, it was also testified to that those are not indicators per NHTSA. And if NHTSA's the rules we're going by here, that's not an indicator. There were also an indicator that she was speaking, her speech was normal, it wasn't slurred. You know, as far as that goes. You know, that time there was no admission to drinking and only the slight odor of an alcoholic beverage. Your Honor, his training is to remove them from the vehicle upon smelling any type of odor of an alcoholic beverage, even faint. So what was testified to here today, and any of the exit the vehicle cues were not testified that they were there. There wasn't any divided attention tasks given. There was no medical questions given. And there was no other divided attention task given during phase 2. Your Honor, we don't believe that there was sufficient reasonable suspicion to continue on to phase 3 pre-arrest screening, but assuming that the court were to find that for argument's purposes, when you get to the horizontal gaze nystagmus test, Sergeant McFadden testified that, and we stipulated to the result, that that is the test. It is the most reliable, it is the most predictive, it's got the most scientific backing per the studies that are published in the manual. And in fact, that if someone can't perform the other test, the officers are taught simply to go with the horizontal gaze nystagmus test. Well, at that time, if he proceeds to pre-arrest screening and he gets 2 clues on the horizontal gaze nystagmus test, that should have stopped the inquiry right there per the training. At that time, there wouldn't have been reasonable suspicion to continue on giving field sobriety testing at that point. And if there's not further reasonable suspicion at that time to continue the field sobriety test, there's certainly no probable cause to arrest at that point. There was an objection to anything dealing with a portable breath test coming in, so what the court has to go on is what has been presented here today. Additionally, Your Honor, there was no evidence set forth by the state As to the breathalyzer, in regards to the written procedural manual being kept in the area, and that the instrument checks, controls, and certifications, calibration checks, and records of service and repairs were not retained in accordance with paragraph A of Rule 3701, 5301. So the breath test, Your Honor, I believe would have to be suppressed as well.
I didn't even know that was an issue. Okay, Mr. Hill.
Well, Your Honor, I would make a brief rebuttal as to the idea that, and it is in the manual, that the horizontal gaze nystagmus is the most reliable indicator, but I don't think that there's anywhere that it says that supersedes or overrules any other tests or any other observations that are made. And I think it's also possible to be impaired and not have those clues also. There were 2 clues, so it wasn't 0 clues. So we don't accept that argument, and otherwise we feel like that there's plenty of evidence all the way around.
Okay, take some notes, because I'm going to take this under advisement, but I want you to brief me on some things. On the HGN testimonies, there's 2 of 6 clues, but there's also testimony that takes 4 of 6 to indicate impairment. So I want to know about Mr. Kermeen's argument. Should that have ended the inquiry at that point? You know, it's the first test given, that's his argument. Once you do that test and there's only 2 of 6 clues, and that under the standard doesn't indicate impairment, should that end the inquiry? Or can you go on to other things? The second test given was, or attempted at first to be given, was the walk and turn, and it wasn't given. And I saw the video of that whole proceeding. The officer testified and said he can't say it was impairment that kept her from doing the walk and turn. So I think I got to take his testimony of that. That test is of no value, or even the instruction phase and the observation of her. She did seem to be a little unbalanced then, but he can't say that was because of impairment. So I think that test is out. The next test given is the one-leg stand test, and that comes in, as far as I'm concerned, for what it is. Are those clues enough? Can we go on from the HGN, because it's only 2 of 6 clues, and get to the one-leg stand, and is it enough by itself to indicate that we've got impairment? And then the portable breath test, I always wonder why do we go to this other stuff? Why don't we go to a portable breath test first? But here we don't even have it in the evidence. And I'm assuming that's because of some discovery issues that we don't have a portable breath test. So I can't even look at that. I don't even know what the score is, and it hasn't come into evidence as to what the portable breath test is. So those are my questions. I guess to sum it up, can you go on after having an HGN, which testimony is that's the most reliable predictive, when you only have 2 of 6 clues, and you should have 4 to indicate impairment, and we've only got 2. Does that stop the inquiry? Can we go on to eventually the one-leg stand and what it showed, and he testified there were some clues there, is that enough by itself? Does that overcome the only 2 clues on the HGM? So see what you can find me on that. That's what I'm going to be looking at to make a decision in this case. Be nice to have some stuff thrown in about standard of proof too. You know, what's the standard of proof for the state on this? Is it beyond a reasonable doubt, or clear and convincing, or probable? I don't know. I'd like to see some evidence on that. I was going to ask, I understand there's a recent 4th District Court of Appeals decision on this whole issue of touching the lawn, but I don't think that's even an issue.
It's not an issue in this one, Your Honor.
So those are the things I want to know about. What kind of time frame do we need to get me some stuff on that?
Who do you want to go first, Your Honor?
I'm sorry?
Who do you want to go
Well, the
first?
state has, I believe, the burden of proof, so they go first. When can you have yours in? And but you get to respond too. You get to go first, he gets to respond, and if you want to rebuttal, you can.
2 weeks?
2 weeks. So we looked for the states, that's the 9th. So yours a week later,
That'd be fine, Your Honor.
so that's.
Oh, actually, Your Honor, could I have 2 weeks on that? Because I'm supposed to be going to a training. There's a multiple-day training, I believe, right around that time.
Okay, October 23rd, defense, response.
I'll try to have it in sooner than that, but just in case.
And then any response from the state, and for me to make a decision, I'm going to put it on my calendar, October 30th. So really, the only thing I need put on the calendar so it'll come up to remind me is October 30th to look to see if the briefs have been filed, and I need to read them and make a decision. I'll make a decision after that. Okay, anything else?
No, Your Honor.
No, Your Honor.
Thank you.
Okay. Court's adjourned.
You're just saying, I think you're supposed to step up a lot. I just want to set the steps in.
Appreciate it. Sure. Right.
You have to be able to move on.
Right, exactly.
I kind of figured when you were looking at the room, I was like, it's probably been a while. I'd say you don't get out on the road as much as you used to.
Well, I appreciate it.
Thank you very much.
Yes. I will be here.
The PBT's never